Okay. Okay, we've got everyone here who's going to be here. All right, looks good. I'd like to call this meeting, the Clay County Commission, to order. We will begin with our invocation from Doug Gary, so if you would come forward. And as he comes forward, please remember that if you want to speak to the commission on any subject, make sure that the button is pushed so you've got the green light on around the collar of the microphone. State your name and speak clearly into the microphone for our audio recordings, and then proceed with whatever it is you have to say for us. So with that, we will have our invocation.
Lord God Almighty, creator of heaven and earth, we come before you grateful. It might be easy to, in the midst of the burdens and the busyness, forget the blessings that you've poured out on Liberty and Clay County. There's places where fires ravaged the whole city, where war has devastated, where hunger is rampant. And we're grateful for the abundance that we have here, for protection and provision, for freedom of speech and religion, for the hearts that you've put in the people here to care for one another, to take care of each other. We're grateful. As the world goes through all of the things it's going through, we know that the solution isn't really one political party or another, but more of you. More willingness to wash each other's feet, to seek justice for the needy, to love one another like you love us. So we come before you praying for Liberty, for Clay County and all of the cities that are a part of it, that you would be manifest more and more in this place, that the people that love you, that claim you, that say they worship you, would more and more manifest your love for the people around them. We thank you for your blessings, for your watching over us. We pray for wisdom for the leaders that we've set ahead of us to make decisions in all different capacities through the county. We thank you for this time. We ask for your wisdom. You said you would give liberally and without reproach. Even if we wasted it last time or didn't use it like we should, we can always come to you and ask for more. So we come asking for wisdom as we may all make decisions in our lives that matter, that affect others. In obedience to your command, we pray all this to the Father in the name of the Lord Jesus Christ. Amen.
Please join me in the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. That brings us to our roll call.
Commissioner Nolte? Here. Commissioner Withington?
Here.
Commissioner Lawson? Here. Commissioner Wagner?
Here.
Commissioner Carpenter?
Here.
Commissioner Thompson? Commissioner Johnson?
Here.
Next item on our agenda is the approval of the agenda. Is there a motion related to approval of this evening's agenda? Commissioner Wagner.
Thank you. Move to approve tonight's agenda.
Motion has been approved. Motion has been made for the approval of this evening's agenda. Are there any discussion or any comments? Seeing none, you are recognized to close.
I close.
Please call the roll.
Commissioner Wagner?
Aye.
Commissioner Johnson?
Yes.
Commissioner Withington,
Yes.
Commissioner Lawson,
Yes.
Commissioner Carpenter.
Yes.
Motion passes 5-0.
Thank you. Next on our agenda are public comments. We have some issues that we're going to be discussing later on, so if you are wanting to discuss those issues, it might be more productive to make those comments at the time we bring that issue up. However, if there's anyone here who would like to make any kind of comments from the public, please approach the podium and we will be happy to hear them. Seeing none. That brings us to our consent agenda. Deputy Administrator?
Yes, Commissioner. The consent agenda allows the Commission to act upon items considered to be routine and approved in one motion. These may include items that have been reviewed by the Commissioner in a prior session. There will be no separate discussion unless a Commissioner requests that an item be removed from the consent agenda and considered separately. We have one item tonight on the consent agenda, and this is for approval of the Commission meeting minutes from September 28th, 2023, 6 p.m. meeting.
Thank you. Is there a motion related to this evening's consent agenda? Commissioner Wagner.
Thank you. Move to approve tonight's consent agenda.
Motion's been made for the approval of the consent agenda for this evening. Are there any questions or comments from the commission? Seeing none, you're recognized to close.
I close.
Please call the roll.
Commissioner Wagner.
Aye.
Commissioner Johnson.
Yes.
Commissioner Withington,
Yes.
Commissioner Lawson.
Yes.
Commissioner Carpenter.
Yes.
Motion passes 5-0.
That brings us to this evening's regular agenda. There are two items, the first one being 2023-321. Deputy Administrator?
2023-321 is to approve emergency purchase for duct cleaning from Midwest Duck. That is brought to you from our Facilities Division. As we've been doing changes and remodeling in the building, and we've been doing a restoration book project downstairs in the Recorder of Deeds, our vendors that we have been using have gone through and suggested that we go through and clean the entire building's duct system. We reached out to one of our vendors that is actively working on our restoration book project, and that vendor was able to provide us with one of their subcontractors that was able to come out the same day that we made the call, come through, give us a walk through all the building. The next day we had a bid in hand, and we were able to then schedule them 3 days later to start the project. We have a looming time deadline with our tax season coming upon us. So this vendor was the one that was able to start absolutely immediately so we can get our building returned and back open. So we are asking approval for our emergency purchase through with Midwest Duck Cleaning Services.
Thank you. Are there any questions or comments before we hear from the public on this, before we open it up from the commissioners? Is there a motion related to 2023-321? Commissioner Wagner.
Thank you. Move to approve 2023-321.
Motion's been made for the approval of 2023-321. Any further discussion? Seeing none, you're recognized to close.
I close.
Please call the roll.
Commissioner Wagner.
Aye.
Commissioner Johnson.
Yes.
Commissioner Withington,
Yes.
Commissioner Lawson.
Yes.
Commissioner Carpenter.
Yes.
Motion passes 5-0.
Second item on today's regular agenda is 2023-322. Deputy Administrator?
2023-322 is the request for a conditional use permit for an exotic, dangerous wild animal facility. And we have Director Kip Jones with Planning and Zoning here to present.
Please proceed.
Kip Jones, Planning Director. So this is a conditional use permit request for an exotic dangerous wild animal facility. So I'm going to show you the property here a little bit, and then we're going to go into more detail. So it's outlined in yellow on the screen. It's approximately 3 acres in a platted subdivision called Cary Hills North, which was recorded in 1985. It's zoned residential rural, which is R1 zoning. At the time this was platted, R1 zoning was standard for a roughly 3-acre lot. Currently, to do R1 zoning, you have to have 10 plus acres, and we'll talk about that more here in a bit. There is a single-family home and an accessory structure on the lot, and it is within a mile of the city of Kansas City. We did send requests for comments to the city of Kansas City. We have not received any comments from the city. So this is a unique case that has gone in front of the Planning and Zoning Commission and County Commission several times. So I kind of wanted to go over a timeline because it can be confusing, and I think there was some confusion at the Planning and Zoning Commission as to what occurred when. So in April of 2015, staff became aware from a citizen complaint that there may be exotic animals on the property. We inspected the property, saw that there were possibly exotic animals, met with the property owner, decided that a conditional use permit was required, and the applicant or property owner applied for that conditional use permit in May of 2015. That's when the public meeting started. By September of 2015, that conditional use permit was approved by the County Commission with 15 conditions. And I want to go over a couple of those conditions because I think it's important to know what those were. It was required that an 8-foot tall fence would go around the entire property. The applicant will give you more information on what fencing exists currently. There was some vegetative screening conditions to screen the property from the adjacent properties. And really the biggest condition or most restrictive one was that the commission limited the animals to a number of 30, and the lynx and caracal, which are the couple of the larger cats, were not allowed. The 4 servals that the applicant had at that time were allowed, but they could not be replaced after they passed away. So the CUP was approved, but it put some strict conditions on it at that point. In October 2015, that's when the applicant appealed this to the circuit court. She appealed that decision to the circuit court. That's a standard appeal process for any county commission decision. So roughly for the next 5 years, that case was in court. I do want to note that the Planning and Zoning Department did not enforce the conditions during that time period as it was in court. In February of 2021, a new application was submitted because the court basically said, hey, county, you can either provide additional information, or since that 5-year CUP is up, you can allow the applicant to reapply. And that's what occurred, is the applicant reapplied in 2021. By July of 2021, that CUP was denied by a 1-1 vote at County Commission. I failed to say in the first case, Planning and Zoning Commission voted 3-2 to recommend approval. In the second case, the Planning and Zoning Commission voted 5-0 to recommend denial. So that second time, the CUP was denied by County Commission. In August of 2021, again, the applicant appealed that in circuit court. It's my understanding that that case is still in court. The applicant submitted a new application in May of this year, and that's why I'm standing in front of you today. So that's the background, and now I'll go into the case in a little more detail. Again, the request is for an exotic animal facility. This is not a facility that people come and visit the animals. The applicant will provide more information, but basically she takes the animals off-site, educates folks, gives presentations on the animals, but no members of the public come to the site to view the animals. She is licensed by the USDA. The animals range from lynx to goats to lizards. There is an animal list that's in the conditions. The total submitted by the applicant is a total of 61 animals. Staff believes 54 of those animals to be exotic, and the applicant has submitted a business plan which is required for any conditional use permit. So I want to show you the surrounding area a little bit. Right there in red is our subject parcel. Anything in yellow and orange are residential zoned lots. There's a lot of 1 to 3 to 5 acre lots in the orange and yellow. And then to the east and west, there still is some large ag zoned lots in this area as well. Now, we'll talk about the comp plan here in a minute, but you can see just to the south and west, right there is city limits of Kansas City. So 92 Highway is north. So this is south of 92 Highway, but north of Kansas City city limits. As far as the comp plan and land development go, the comp plan tells us this is in the urban services tier. That's typically the area that we're going to see development. So I would expect more development to occur in this area over the next few years. With our land development code, as I stated earlier, this parcel is zoned R1, residential rural. In our current code, it says if you're zoned ag or R1, to have an exotic animal facility, you need to have a conditional use permit. So that's why the CUP is requested. As I stated, our current code, if you're rezoning to R1, you have to have 10 acres. but since the property was rezoned R1, it's basically grandfathered in, she's still allowed to apply for that conditional use permit. These are the 6 criteria for a conditional use permit, which the burden of proof is on the applicant to show how she meets these criteria. When staff presented this to the Planning and Zoning Commission, we presented that we felt there were 3 criteria that had not been addressed by the applicant, and I'll go over those briefly. They're highlighted in yellow. It's that the proposed use in its proposed location will not have a substantial adverse impact on the public health, safety, or general welfare. Number 2 is the proposed use will not cause substantial injury to the value of other property in the vicinity. And number 3, the proposed use is compatible with adjacent uses in terms of scale, site design, and operating characteristics. Those were also included in the transmittal that was sent to the County Commission. Some additional information, we have received opposition for this case, and I believe there's some folks that will talk tonight. We followed our public notice requirements, and we've received no objections from outside agencies. And again, she is licensed by the USDA. There are multiple letters of support that were included in the packet as well, and some additional information that was provided by the applicant. The Planning and Zoning Commission voted 8-0 to recommend denial in this case. However, if the County Commission votes to approve, staff recommends approving with the conditions that were included in the transmittal. The Planning and Zoning Commission had discussion about this not being the right location for this type of use with the lot size, the proximity of the houses, and I should back up. I do want to show you. So there is a house. That's a house right there. And that's a house right there. Those are the 2 closest houses. I think the closest one is roughly 180 feet from the property line. So I apologize, I failed to present that. But Planning and Zoning Commission voted 8-0 to recommend approval. Talked about the location, and then talked about, there was a lot of discussion about the conditions and the lack of improvements that the applicant had made over those roughly 8 or 9 years that this has been kind of out there. So the applicant has a presentation that they would like to present. I believe we have some folks that want to speak in favor of this and some folks that want to speak in opposition. And also Mr. Tom Decker, who's the chairman of the Planning and Zoning Commission, is here tonight, and I believe he wants to say a few words as well. I would be happy to answer any questions that the commissioners have.
Thank you. I think the way we'll proceed is I'll first off see if the commission has any questions of you, Mr. Jones. Does anybody have any questions or comments that they would like to make at this point? Commissioner Johnson.
Just a real quick question. You said the applicant's licensed by the USDA. Licensed for what?
She can give you more details for that, but basically to possess the exotic animals.
There's a license to possess exotic.
Yes.
Didn't know that.
Okay, we will, let's see, I guess we hear from the, we want to hear from Mr. Decker first. Is that?
My preference would be we hear from the applicant and then go to public comment.
I was thinking that might be the better way to go, but I'm kind of looking for a little bit, okay.
Yeah, that'd be
and
my
that-
preference, is the applicant has the burden, the applicant would go first.
All right, that sounds good to me. If the applicant would like to make a comment, please step forward. And as I said, please, the green light is on. Make sure that you identify yourself, the audio recordings, and then after you've made your statements, I will be asking the commission if they have any questions or comments related to what you had to say. So please proceed.
And commissioners, just
Sure.
so you know, because of the nature of this one, I think I've talked with Mr. Bear, who is the counsel here. I think we are going to do sworn oaths for each testifying witness. So
Okay, well, I don't think we've done sworn.
we've done that in the past, but not frequently, but it is something we can do.
So what is the procedure for doing that?
The county clerk will swear in each witness who intends to testify.
Okay, and does that include the applicant as well?
Yes, it'll include the applicant. Would not include applicant's attorney unless he's offering testimony or evidence, but typically would include the applicant.
Okay, so you, sir, are the attorney, so that would be your option, but from here on out, any other persons testifying will need to go under oath, or at least be sworn in.
That's right.
Very well. Please proceed.
And under oath, I'm going to ask Kip, how do I think I messed something up. How do I do this? Oh, yeah, please.
There you go. Okay. If it does that again, just hit the button.
Can I do the run thing, or
Do the what?
is there a way for me to zoom up on one page?
I have no idea.
Okay.
I don't know your program, I'm sorry.
No, it's okay.
different than mine.
Okay. Well, as Mr. Graham said, my name is Brian Bear. I represent the applicant, Jen Kasserman. And, one of the things that Mr. Graham has alluded to is that this is a contested hearing because we obviously have a difference of opinion with planning and zoning staff. And as such, Ms. Kasserman is here to testify under oath, to answer questions under oath, to give your assurances to you under oath if there are conditions that the county wants to put on her use of this property. And so as we go through this, I think that you'll see that, one, she has been licensed by the USDA, which has very strict requirements, both on safety, number of animals. She is inspected every year by the USDA. We can go into that and answer questions. We even have her former USDA inspector in the audience today to answer questions under oath about her operations and whether she's been in compliance with the federal regulations for this thing. So, as we go through, I'm more than happy to answer any questions that the commission has. Certainly, one of the things that we requested before this was to make sure that we are able to address any evidence that the commission has. I've been told that the letters that have been given in support and the letters that have been given against her were included in the packet. And just if there are any other communications, evidence that the commissioners have received, I'm more than happy to address those if those have been presented to the commissioners as we go through it. Because one of the most important things is we're hoping that Ms. Kasserman has the ability to answer those questions on the record, under oath, and be able to provide explanations for any concerns that the commissioners have. I do want to talk a little bit before I go into the presentation about the timeline Mr. Jones presented. It is largely accurate with just a couple of addendums that I put on that. First, when Ms. Kasserman appealed the 2015-2016 conditional use permit that went to the commission, she appealed a narrow subset of that. There were a host of animals which are smaller. Those are things like fennec foxes, porcupines, the non-cat species. She was fine with that portion of it. Her issue that she had, and the only place that she could seek relief, was the circuit court. I believe Mr. Jones' characterization of that as normal part of the process. It is the only process that you can do if you disagree with the commission, is to go to circuit court, was on the issues of the servals, the caracals, and the lynxes. And her issue that she had was that there were not findings of fact that these animals were in fact dangerous. There was a normal vote. And the circuit court agreed with us that one of the things that was required was a finding of fact by the commission that these animals were in fact dangerous. And so one of the things I want to emphasize throughout that, and it's not chest pounding or anything like that, is that we ultimately prevailed on that issue with the circuit court. They did send it back, but because of the time frame when we got a decision, there was only 6 months left for renewal, so we submitted that renewal. That was a very important part of the process, and I want to make sure that fact is before the commission, that it wasn't a dissatisfaction with the entire deal. It was only on a portion of the commission's finding on that. So when we're going through this, this application, the one thing I would like to emphasize with this, and I also have these slides for the commissioners themselves, if you'd like to have a copy of them and make it part of the record as well, that the actual EDW permit, Ms. Kasserman has held that before. The commission has seen fit previously to grant her that 2015 commission, or that 2015 EDW permit. So this is not a situation where this is somebody's first time permit or where they have not ever been permitted before. There was some objections, as I noted, with that previous permit, but she did go to circuit court on that. The other thing I want to emphasize as well as we talk about the nature of the property that she has is that, actually, let me see if I can do it this way. Yeah, this is going to go a lot better. Apologies, I was trying, if I use the mouse, I think it works. That the animals, and you have a list within the application process of all the animals that are out there. And I think that there are really two buckets to the animals to consider. One are the cat species, which are the lynxes, the serval cats, and the caracal. And the other are all the other small animals that are out there, like the fennec foxes, the porcupines, the yellow-footed tortoises. And so one of the things that I want to emphasize is that this is not an all-or-nothing request. We are open to conditions on this permit. I believe that the permitting process allows the commission to regulate a CUP very effectively. But I do think it's important to note that for those smaller animals, there's really no evidence that has ever been presented that a fennec fox that weighs 2 pounds is somehow a danger to the public or affecting property values. So one of the things that I would ask the commission to do as you go through this list and look at these individual animals is really ask, is this an animal that's going to impact property values? Is this something that is a danger to the public? And if you can't answer that yes, if you feel that there isn't evidence in the record to support that, that we at least put those animals on Noah's Ark, as it were, and take them off the table. Let's focus on what the real animals are that are causing the friction on this. And I think, to be absolutely upfront with you, I believe that we have evidence to present to you that each and every one of these animals is something that can be cared for on this property safely, properly. She is subject to the regulation of the USDA for all of these animals. And she has never had a violation from the USDA for any of these animals and has been operating continuously. Kip's statement about the lot in question, we largely agree with everything about it. We do have some information that I think would just be duplicative of what we already have. But the one thing I want to emphasize is that first factor, which is about that it meets the intent of the code. One of the things I want to emphasize about this is that this is a residential rural R1 designation. And what that means under the code is that somebody who owns that land, whether 3 acres or 10 acres, they can have cows, they can have goats, they can have large animals on the premise. So when we talk about the intent of the code, one of the things that's baked into it is if you buy a house in a residential rural R1 division, you're expecting to have some form of animals, and even large animals, as part of it. That's baked in to that zoning, and that is how the adjacent lots are zoned. So the issue that Mr. Jones really wanted to emphasize was about value. And one of the things that has changed from the time that we submitted this application and the time that we went in front of the board is that there's actually been a residential sale of one of her adjacent properties behind her that just went on the market in the last 2 weeks. And Ms. Kasserman can provide that. I have a slide on it to provide that information, but from her investigation and speaking with the realtor, not only did that homeowner have an offer above asking price within 5 days, they had multiple offers, and now they're accepting a backup offer. So in real time right now about property values, which was one of the most important things that Mr. Jones emphasized, we have real data of what the market is doing right now of an adjacent neighbor. And they have had no difficulty selling their land. And in fact, we have sales from property owners throughout this, the last couple of years. And in each case, we have property that has been on the market for a very short period of time. We have property that has been sold at or above asking. And so, staff candidly says in their report that they don't have data about an impact on one way or another on adjoining property values. There are folks who have submitted comment where they have said, we feel that our property is worth less, but what the market has actually done and the empirical evidence that is actually out there supports that this is not actually injuring property values. The other thing that has changed since the planning and zoning meeting is that, in fact, the number of animals have gone down. At every juncture that we've submitted these, the number of animals that she has had on her property has gone down. And specifically, one of the areas of concern that the previous commission expressed and that planning and zoning expressed were about the lynxes. She had four lynxes she was trying to permit when she went in front of zoning. One of those lynxes has passed away from natural causes. Ms. Kasserman can tell you that she has no intent to replace that lynx. And in fact, if you put a condition on her CUP that said that the existing lynxes, once they pass away, she will not replace them, she would accept that. And she would be fine going forward once they pass away from natural causes of not having any further lynxes. There is a caracal cat. That cat is currently not living on the property. Instead, it has been donated to a research institution and zoo, I believe in Portland. Ms. Kasserman can provide testimony on that. If a condition is that that animal should live in Oregon and should not come back, we are willing to accept that condition, and she's willing to tell you that under oath. So this is not something where Jen is digging in her heels and where she just is all or nothing. She's willing to entertain and move this property in the direction to the conforming uses that the commission sees fit. But with the serval cats, she's willing to accept absolutely a limit on the number of serval cats, but please understand what the stakes are for her. A lot of these cats have injuries. They're not ill, it's not a public health issue, but they have an injury that basically makes them unmarketable to transfer them to another USDA holder. One of the things about these animals is you can't just give them to somebody off the street. You have to have somebody else who has a USDA license. And so the reason Jen has gone to court, and I want to emphasize this so much, is for a lot of these animals, if they are not permitted, they're going to be euthanized. That's why she had to go to court. That's why we asked for a stay and received a stay with the county and with the court in 2016 and currently with the current court case, is because understand that if these animals are not permitted, she's going to have to euthanize these animals, and she'll tell you that under oath. But putting that aside for the moment, I think that when you look at the things that she has done to this property to keep it safe, the amount that she has invested in the property, I think you're going to be taken by the amount of money she's invested, and which will all go up in air if the commission does not approve this CUP. I think you'll also be struck by the fact that this exceeds, in many cases, the USDA recommendations for a secure facility. So, talking about the USDA and the risk to the public, one of the things I hope the commission understands is that this is not a Tiger King scenario. Unfortunately, popular media has kind of created that sort of instance. These are not lions and tigers. These are not large cats. The largest ones are about 30 to 40 pounds. They are kept in large commercial cages. Ms. Kasserman will tell you under oath that she spent about $100,000 of her own money over the years buying these types of enclosures. There's multiple layers to the security. Planning and zoning has been out, and they've seen these structures. They are affixed to the ground, and so if she is not able to keep animals in them, they can't be removed, they can't be sold. It's going to be 100% loss to her. So one of the things that I also want to emphasize is that as part of that stay order with the court, if there ever was an animal escape, if there ever was an injury, the court had put into its order that the stay went away and that the county commission's order immediately came into effect. So she's been under the gun for the last 3 years. If there was an animal that escaped, if a member of the public did get injured, if there was a violation cited, she would lose these animals. She understood that. She kept her word. That stay is in place. There have been no violations of that stay order. And so one of the questions that you have as a commission is, can you trust this person to abide by these conditions? Whatever somebody may say about that, the proof is in the pudding with what she has had to do with the circuit court. And there have been no cited violations from planning and zoning during the pendency of this entire stay order. And she knows the stakes about it. I want to talk a little bit about danger, about these animals together. I made the Tiger King comment. I appreciate the chuckles on that. But I want to back it up with facts for you. So the USDA on this slide, and I'll try to zoom in because I know it's small. This is from their inspection guide. And so one of the things that it lists are animals that are subject to a license, animals that are dangerous, and animals that are potentially dangerous. And so if you look at the dangerous animals, they're the ones that we all kind of expect. And here, let me even zoom up closer. Lions, tigers, wolves, bears, elephants. That makes sense. Potentially dangerous animals. Large felids, okay, plural of feline, as I learned from my client, that include lions, tigers, leopards, cougars. Now, if you go up there, there's another classification of not dangerous or potentially dangerous. These are special license needed. And those are, as you see, the lynx, the servals, the caracals. Those are the animals that are put away from the designation from the USDA, the federal government, which we know, has anyone ever known the federal government not to like regulating things? That they are willing to regulate as dangerous, these animals, potentially dangerous, another subset, but for the animals in question, these simply require a special license. And that isn't to say that it's just fill in the application and the federal government gives you your permit. That is not the case. She's subject to inspections. She had to do fencing. We can go through all of that and answer any questions you have about what's actually on site and what she has done to make sure that, that these animals are safe. So she has had these animals for the past decade, and not once has any of the EDW animals ever escaped. There's never been injuries. There's never been an incident where somebody in the public has been hurt. And she takes a lot of these animals out into the public, to schools and to places for enrichment. You know, this is something where, this is not a situation where the animals have been running amok. They stay in their enclosures. There's never been a report nor an incident where there has been a risk to the public. There have been folks who are worried about something that may happen, but if it hasn't happened in the last 11 years, 10 years of her operating this, I don't think it's happening. I don't think the evidence is there. Substantial injury to the value. That was one of the issues Mr. Jones identified as being particularly important. So this is a slide that Ms. Kasserman created. We obtained this data from Zillow, which actually combs the information of sales from the county's own records. And so if you look, these are the properties that I was mentioning. In 2020, there was a sale. Ms. Kasserman's is the yellow triangle. I think that's a obtuse triangle, I believe. Next door in 2019, there was a sale for $400,000. There was a sale in 2020 for $300,000. And then this is the one that I just mentioned, which is the pending sale that happened just in the last week, that is immediately behind her property and abuts it. And, you know, there may be some people who ask, okay, but do these folks know that there are wild animals there? One of the things she was required to have is to put signage, not just in front of the cul-de-sac, but in every quadrant, facing every homeowner, saying that there are animals on site. If people can sell their properties at or above market value and have multiple offers over asking with a sign like that, you know, it only proves the point that people know what they're doing. They're moving into a residential R1, and her property is not creating an issue for those adjacent homeowners. You'll notice that within the area, there are significantly large property which have very significant asking prices. That one is located to the east of her. Further south, we have one that sold in 2023 where it's being sold for 170 square foot. That is a little bit further south in the development. There is the one that is also part of that development, which is also selling. It's even further away, but it's selling for an even smaller dollar per square footage. So if you would expect that this was affecting property values, the closer you get to her property, you would expect that that would be worth less. There would be less square footage per dollar as you start to move closer to her property. But actually, when you're moving away with these sales, the property prices are going down. The one that I wanted to emphasize, this one in particular, this is the 295 one. That was her neighbor on that chart. That sold for $209 a square foot, which is immediately in the area for hers. And then this is the one that just went on the market and the data that we have. So Ms. Kasserman can authenticate all this under oath. But basically, they put it out for, let me explain this slide to you. So they bought it for $169,000. They were able to sell it for $390,000 or more. We don't know the terms of the offer, only that it was at or above asking price, and she had multiple backup offers on it. And by the way, this went to backup offers within 5 days of being put on the market. This was the next door neighbor to her that sold recently as well. Again, it's selling for $400,000. It was only on the market for a limited period of time, just a matter of days. And this is one of her immediate next door neighbors, and it was able to sell. So if we were really talking about this creating some kind of blight or issue on her neighbors, the actual empirical data of the marketplace says that that's not the case. We did receive emails from the Planning and Zoning through a sunshine request. And this is from the previous proceeding from the homeowner. I have redacted that homeowner's name for privacy reasons. We can provide that, and it's within your records if you want to see the actual person's name. But it is the person who lives at 7815 Hauser, which was that $400,000 sale. And I think this is one of the best pieces of evidence. Had we been told, had we not been told by our realtor, so they were told by the realtor of the animals next door, we wouldn't have known of the situation. We have yet to encounter any smell, sound, or safety issue. We are not aware of any large, dangerous animals, nor have we felt threatened by the animals residing there. That's from the homeowner in an email to Planning and Zoning. And so the fact that they bought this, that it was disclosed to them, there have been some questions at prior meetings. Are members of the public actually understanding that there is this use next to them? Yes, they are. In fact, there are plenty of signs that are put up on every quadrant telling them of that fact. The traffic hazards, I don't think that was an issue. I think we've all agreed that she's not open to the public. This is not a situation where she has cars coming by her. Adequate public safety, transportation, and utility facilities. I don't think that's really an issue on this one. There is an issue with trash and waste pickup that have been raised in the past. She has a service that collects the animal waste. It is not disposed of on site. It is not disposed of in water. So, and by the way, the USDA also inspects her for cleanliness of the animals' enclosures for their welfare. So this is not a situation where she's operating without a net or without supervision. The feds do check on that. Odor, dust, lighting, and noise. About the odor, I would submit that email that we spoke about just earlier. I'd also state that, we are dealing with a situation that is zoned residential R1. There are horses. There's a horse barn next to it as well. So, this is not a situation where there's a bunch of single-family homes in a close-knit subdivision right next to her. There are horse stables and large animals right next to her. So if anyone is going to talk about an animal smell, of which that homeowner said candidly to planning and zoning that there were none, and they are her neighbor, is that really Ms. Kasserman or is it the horses? That is, there was an instance where somebody gave a statement where they said, oh, the animals are up at all matter of the night. Ms. Kasserman will tell you none of these animals are actually nocturnal. They all sleep during the evening. And if you've been in rural parts of Clay County, there are plenty of animals that make noise throughout the evening. I don't think anyone can credibly say that it is her animals that are doing it, especially when each of these species goes to sleep at night. The other thing I would point out is the fencing and the shading. You can't see any of these animals. And I think that email that I've submitted to you proves that the person was saying to the Planning and Zoning Commission that they couldn't even tell that there were animals unless they were told about it. One thing I do want to talk about the standards of the code, there are preferences that staff had. There are times where they've requested additional fencing, additional signage. For instance, the signs, just for example, the actual code says there just needs to be one sign facing the public thoroughfare, and there's only one road, which is that cul-de-sac. Now, that's a strict reading of the code. That's actually what it says. Staff wanted a sign in each direction towards each neighbor. She didn't fight that. She put up the signs that she was required. So we have been asked to do things beyond the code, and she is willing to do those. She has gone above and beyond about what the code is actually required, and is flexible about arriving at some sort of condition to get some of these animals permitted. And we do think that the facts are here that all of these animals can be permitted. This was an email that we received from Mr. Jones in 2021. This was prior to the other litigation where she's been under that stay order, as I said, that if there was a complaint, if there was an escaped animal. When we had that 5-year period, they had not received any complaints since the CUP was approved for the first time. That was, remember, it was approved in 2016, so that's 5 years. And now we've had another, was it 3 years? 2015, sorry, thank you, 2015. So 2015 to 2021, that's 6 years plus the 3 years that this has been before the circuit court. She has a USDA license, we have a copy of it. She has never had a failed inspection by the USDA. They inspect her every single year. They do it on a surprise basis. They don't tell her when they are coming. She has never failed an inspection. So what does she do with these animals? If you go to North Kansas City School District, she will bring them to the school district. Here are some of the smaller animals, the tortoises, the fennec foxes. Yet, under the previous determination of the board, and that is a serval in the middle. That's the dangerous cat, folks. That's the cat. It's a younger one, but these are animals that go out into the community for enrichment. And, at the end of the day, are we really saying that none of these animals can be permitted, that all these animals are dangerous to the public or affecting property values? There has to be some that can get permitted, even under the most extreme views. And I think all of the evidence that we have, look at the USDA's evidence, look at her track record on this. These animals are not a danger to the public. They've never injured a member of the public. She is an educator. She can talk about how she does outreach in the community. She can tell you about the research activities that her animals participate in with entities like the National Institutes of Health. There is an exception in the code where research and educational use of EDWs is something outside the permitting process. That is part of the code. We'd rather operate under a permit as opposed to going that route. We'd rather be subject to the supervision of the commission with that, but that is out there, and that's the evidence that is before the commission. I do want to address some issues with, and I understand that the chairperson for Planning and Zoning wants to make a statement. Our understanding of the Planning and Zoning Commission's issues, because I was there, we were in this room, it was recorded, was that there was an issue with insurance. There was a one-page declaration. We sent the entire policy to Planning and Zoning. We didn't realize that that was going to be an issue. We have a copy of the policy. It's always been in place. It's a $1.5 million policy, general commercial exposure policy. So if there's an issue with that, we've always had it. We just weren't apprised of that before the meeting, that the zoning board didn't have it. There was an issue with the contingency plan that the board did not have. We have a copy of that. That's always been in place. That has been given to staff. We also have a site plan. One of the issues that we've had is that the site plan and the contingency plan talks about where her gates are, where there's ingress and egress. And so for security measures, we wanted assurance that that would be treated as a closed record, because if you show folks where your locks are, where your doors are, how you keep it secured, kind of defeats the purpose of what we're trying to do. And that we were not trying to hide the ball on that. But I want to emphasize, we've always had that in place. If we had known, we would have presented it before the board. But we have those here today. More than happy to give them to you for inspection. We're even fine if we want to table this matter after you hear testimony, if you all want to inspect that, if there is additional, whatever the commission requires as far as documentation, we are here to provide it. If there's testimony you want to hear, we are here to provide it. And, we're just hopeful that you'll understand Ms. Kasserman does want to be permitted. She does want to operate under a permit, and we are willing to have that conversation under oath and get to the, hopefully, a resolution of this issue. So with that, if there are questions that the commission has, I'm more than happy to answer them. And I know I got a little long-winded there.
Commissioner Lawson?
The question that I have, I was here when you made your last presentation. Well, I was here for another issue, but
Sure.
Was interesting. I think she's trying to do the right thing. I have no doubts in my mind. But the one question I have is, has what the planning and zoning, the standards that they had said, these are the things you must do. Obviously, the fencing's there. Obviously, the insurance is there. What about the animals? There was a definite, and I do want to hear from Mr. Decker, but are those animals that there was some regulation in the county against her having, have those animals been removed, or are all those animals still there?
Those animals are there. They are
Okay.
subject to a stay order with through agreement with council. And the court has put in a stay that basically kept the status quo from when she did her first application in 2016 through the current one. So the circuit court has basically said, I am not going to allow the animals to be removed until we get clarity. So we're back here today because obviously the commission has changed. It was a split vote last time. And the presiding commissioner's vote carries under the statute. So now that there are new commissioners, I spoke with Mr. Graham about that. We wanted to present the issue to you all to make that decision. But if you put in place these sorts of permitting issues, we will comply. But there's never been a period where there's been a decision that has not been subject to the court where there's been a stay. But the animals are on site, and the point of the stay was to allow them to be there because the removal would basically entail euthanizing those animals.
Yeah, got it. Okay.
Commissioner Johnson?
Two questions. Are those the servals in the picture, that serval, is that full grown?
No.
How many servals do you have?
12.
How many?
12?
12 servals?
Correct.
And how big are they full-grown?
20 to,
If you would come into the microphone and identify yourself before you answer the question for the audio.
I need to be.
Oh, no, good point. Yes, before you do answer questions, yes, I'm sorry. I'm not used to the swearing in of witnesses. Madam Clerk?
Do you swear or affirm
Thank
to
you.
tell the truth, the whole truth, and nothing but the truth? Yes.
Okay, with that, please identify yourself as you respond to the questions.
So Jennifer Kasserman.
So when we talk about servals, are there different types of servals or just a serval's a serval?
A serval's a serval.
So they're all
It's
the
the
same?
type of
Okay, so
species
I'm
cat.
familiar with servals, so then, okay, and then what was that 8-foot fence? What's that supposed to keep in?
So the 8-foot fence actually is a perimeter fencing, and its purpose is actually to keep other animals out and people from the property. It's not meant to keep the animals in. The animals are inside their enclosures with extra
Yeah.
security around them.
Okay. I was gonna say, because that certainly won't keep a serval down inside.
Servals actually have tops on top of theirs, so because of their ability to jump.
Yeah.
So yeah, a serval has to have a top on their enclosure, and all of ours have that.
Jen, for clarity, could Jen provide you with kind of the layers of the protection that she has? Because there's the fencing, there's enclosures, she could probably.
No, actually, you don't need to provide it to me. I'm satisfied with
Okay.
what I already know. I just thought if someone made you put up a fence, an 8-foot fence to keep a serval in, that's not gonna work. I was just curious as to what the logic was behind the 8-foot fence, but no, that's okay. I'm good. Thank you.
Commissioner Wagner.
Thank you, and thanks to you both for the presentation. A few questions. Just so I understand correctly, the 2015, or the appeal on the 2015 CUP was based on the servals and links, which now I understand we are prepared to do things to alleviate that. Correct?
That's correct. The original decision in 2015 was no lynxes, no caracal, and 4 servals, but we didn't have any findings of fact or conclusions on that, and so that's what we appealed.
I see, but nevertheless, you're prepared to make some changes to accommodate a CUP if it happens now.
Correct.
And to that effect, you mentioned one of the lynxes has passed away. There's a few others there. What is our expectation about their lifespan? How much longer do we anticipate them being?
So lynxes in captivity around like 15 or 16 years is actually something is, quite impressive and hopeful. Mine are over 10 years old.
Okay.
So the one that just passed was born in 2011, so there. So I was like, their lifespan is not expected to be much longer. They're older, they're retired. And yes, it was as far as you saying, the appeal was the animals that were left out, the animals of the question of being 4 servals when there were more than that there on the property.
Mm-hmm.
So what made those 4 safe and allowed but didn't make the others? And the number of animals, when it said 30, we had discussed 30 outside,
Mm-hmm.
and there's never been 30 outside, even with domestic, so.
Gotcha. But at least with the lynxes, probably with their current age and expected lifespan, anywhere between 3 and 5 years.
Right, I'm hopeful to get that, with them, but that would be, that would be them living to the longest special life. Obviously, the one that we lost, it was old age, she had, internal problems there, but he didn't make it to that.
Gotcha. Then, Mr. Bear, you had mentioned some of the documents that apparently the Planning and Zoning Commission did not see. Has staff seen those? Or I can let Kip answer that question, but I guess I'd like to know that somebody in this process has seen those documents.
Staff seen documents discussing that planning and zoning board did not see.
Sorry, Kip.
That's okay. Kip Jones, Planning Director, are we talking about the insurance and the emergency plan?
Yes.
Yes, so if I recall correctly, those are listed as conditions. As I stated, we've never enforced the conditions, but they have submitted an insurance plan, a contingency or emergency plan. I looked through the emergency plan. It looks fine to me. The insurance plan, if this is approved, we would submit that to the county councilor, have him review it. assuming they give the go-ahead, then we're good with it. If we need to ask for anything, we'll ask for anything from the
Gotcha.
applicant.
Gotcha. Kip, stay right there, because you're going to probably answer this question too for me. I'm curious to know the development that has occurred around this property since the business operated, or has been operating. I understand the position that Mr. Bear has mentioned, and I've got a couple questions for him on that. But I am curious to know if that area, or how much housing has developed in that area over the past, I guess, basically 10 years since this first came to us, or has that housing always been there during that time?
Well, so if I'm happy to go back to my picture if you need me to, but the immediate area was divided in the 80s, 90s. So
Yeah.
that's been that way, that
So
existed.
within the cul-de-sac, it's always been there?
That's always been there.
And the area south of there has
Has
always been
it's
there?
always been there.
Okay, perfect.
Now, there is a newer development to the north and west, a 20-lot development that is
Yeah.
newer since this
Gotcha.
occurred.
Perfect, thank you. And then this will be my last one for you, Mr. Bear, and I'll let others who have questions come in. So you mentioned the signage, and you mentioned the fencing, and I guess my question is, I don't think, and if I missed it, that's my fault. Is there a picture of the signage that is generally displayed around the property?
We can provide that to you. I don't believe,
I was like, it's been provided before, Kip.
Oh, okay,
Yeah.
that's fine. So if we need to go down that road, we can.
I can tell you it is for the front one, because I didn't walk the entire perimeter. I've been on the property before.
Yeah.
But the one that faces the street, it's pretty prominent. It's, what would you say about
No, that's the county
the
side.
county one? Okay.
Yeah.
So, but.
So kind of like
Yeah.
so kind of like a 2x2, a 3x3?
So when I asked what type of sign to be provided, Kip's described it as being a street sign. He said that I was supposed to get a picture from the West Falls of what theirs is. I don't know what it looks like, so I just ordered signs. It's a metal sign, so it's not gonna like rot away or fade or anything like that.
Right.
They're about this big,
Kind of like a stop sign, kind of about as big as...
kind of, except it's a rectangle instead of an octagon.
Okay, all right, perfect. And then finally is, does the fencing provide any screening to be able to see what's on the property, or is it screened at all? Or does someone just see and they see the cages, or however the animals are kept?
Okay, so when you pull up to the property or go into the cul-de-sac, I have a gate that actually is closed there. It has screening on it. I will say that it is a fake vegetation screening because the gate moves and opens and closes, so I can't have there. But you see the front of the house, which is, the house, the front property there. When you go behind the house, then I have actually 2 perimeter fences. I've got the perimeter fence for the property that is 6 foot all the way around. Then we've planted bamboo, there's trees, there's all kinds of landscaping that's out there. We've been adding it over the years and added more. Then you step into the smaller spot, which if we go to one of the pictures, even Kip's, like you can see where the lineage is, but the animals are in an inside smaller perimeter fence where their enclosures are, and that has the 8-foot fence that goes around. And that was one of the original conditions, was asked for that fence to be raised 8 foot, so it's 8 foot all the way around, even its gates. And then you can't see, there is shade cloth that is also up, aside from natural vegetation.
Gotcha.
And Commissioner Wagner, I'd also point out that email that I showed you. That is from her neighbor from behind.
Right.
So, next door, sorry. I'm glad that she's here. But that was an email, and she said she couldn't see them when she communicated with staff. And also about the sign, if you want to put specifics on a sign, we absolutely, if you want to say it's 3x3, whatever.
I'm just trying to
Sure.
understand if it's something that's very prominent that can be seen currently or not, so that's...
Yeah, sure.
That's sufficient. I think that takes care of my questions. Thank you very much.
Thank you, Commissioner.
Commissioner Withington.
I have a question for Kip first, and then I have questions for you guys. Sure. You had mentioned in the yellow boxes 3 reasons you guys didn't approve this in planning and zoning. What were those? I couldn't catch it in time. Property value, I think you said was one.
Yeah, so let me get there. So the first one is the proposed use in its proposed location will not have a substantial adverse impact on the public health, safety, or general welfare. Second one is the proposed use will not cause substantial injury to the value of other property in the vicinity. And the last one that we highlighted was the proposed use is compatible with adjacent uses in terms of scale, site design, and operating characteristics.
Have you guys found that this has negatively impacted property values?
So no, so the way the land development code is set up, it's the burden of proof on the applicant to show that they meet all these conditions. When we presented it to Planning and Zoning Commission, we presented it as we don't feel like with the information that we have that they've addressed those conditions. Now, Planning and Zoning obviously was given those conditions. They had some different discussions and they voted 8-0 to recommend denial.
Okay. Now for you guys, thank you, Kip. Have any of these animals ever gotten loose?
No.
Has anybody?
And she can say that under oath.
Yes, no.
No, okay.
Sorry. I want the person under oath to say it under oath.
All right, so no, they've never gotten loose. Have these animals ever attacked anybody?
No.
So no, they've never attacked anybody. So I personally think you guys have met the burden of proof to demonstrate that safety is not a problem. They've never been loose. You guys have met the conditions where you guys have put the fence up. You've put the signs up so all your neighbors see that. Also, doing a quick look here, I think you guys have demonstrated also that you guys have met the burden of proof when it comes to not negatively impacting property values. Just doing a quick search I know you guys did Zillow. I went to Redfin and took a quick look. Looks like your adjacent property values over the last 10 years have gone up 67%, 71%, 75%. Then you look around the corner, somebody's property went up 116%. Another person's went up almost 70%, and another person's 54%. Within half a mile of your house, you have a house that's listed for $999,000, basically $1 million. You have another house that was built in 2009, listed for 1.4 or 1.3, something like that. So I think you guys have met the burden of proof that's just me speaking. So, but that safety was my biggest one. So you said no one's ever gotten out, no one's ever been attacked. So, all right, thank you guys.
Thank you, Commissioner.
Commissioner Carpenter.
Thank you, Commissioner. So in 2015, mid-2015, the government granted you, greenlit this operation, JK Animals LLC, doing business as Exotic RS. Since the government, in this case county government, greenlit this business operation, you made mention, Council, of the investment that would be lost should it be required to shut down. Do you have an estimate, or Ms. Kasserman, an estimate on the level of financial investment that you've made since the government greenlit your operation?
For the loss of everything, I would say at least 300,000 of that. And then then what would be ever future for anything future for business? I also say we are also a non-for-profit. We do have that license also. I don't think that's been.
So the estimate on the infrastructure with the cages, what you've done fencing-wise, the animals, you would estimate at around 300,000?
Yep.
Thank you. Thank you.
Oops. Commissioner Johnson? I don't know if I do not have your mic on, I'm sorry. Give me a moment here. There you go.
Thank you, sir. Yeah, I forgot to ask this last go around. So in the pecking order of your cats, as far as the higher up in the food chain, the biggest, baddest, most violent of the cats, which of those cats would it be? Is it servals or is it?
Honestly, I'm going to say a caracal and a lynx would be after that.
Okay, and then if you threw a wild bobcat into that mix, who would be the highest on that?
A wild bobcat's going to be the highest.
Yeah, okay, and if you threw a pack of wild wolves or wild coyotes in there?
Absolutely highest.
Okay. Yeah, I live I have property not too far from you, and I have bobcats and large packs of coyotes on my trail cams all the time, which I'd be more concerned about those than these animals, but just thought I'd ask that. Thanks.
Yeah, and Commissioner, I would just add to that, we do have the USDA schedule that I showed you, which lists dangerous, potentially dangerous. Each of these animals, they are larger. They fall within you just need a permit and follow the conditions. They aren't dangerous or potentially dangerous.
May I comment on the bobcat part? Also, being USDA, they do regulate the exotics. Missouri Conservation regulates everything that is native species in Missouri. So I would not have a bobcat, or I would not have coyotes, any of that, unless I was working with the rehabber that was rehabbing them to go through a vet system, but that wouldn't be something I'd be taking out to the public either.
You actually do have them, they're just not in here, they're just outside.
Right, yes, they're outside of my perimeter fence. It keeps them out. It's actually very sturdy.
Commissioner Lawson? There we go.
Okay, last question. I'm sorry to keep you. Okay, the one thing I want to make dead certain sure of, so you're saying that these cats don't have a real long life expectancy left. They're not being bred, correct?
For the lynxes, no, correct?
Lynxes are not, I was like,
Pardon?
the lynx are not being bred at this point.
Okay, what about, none of the cats that were listed as
Or that were not.
dangerous, large cats, none of those are being bred, correct? So you won't have any more of them?
I'm sorry, when you're saying the dangerous large cats like that USDA has, because I will never have those.
No, forget them.
Okay.
The cats that our people, our planning and zoning people said, these are the animals that were dangerous, and these are the cats we'd like you to get rid of. Of those animals that they have told you to please get rid of, none of those cats are being bred.
The lynx and the caracals are not being bred. Some of my servals are retired and old enough, but some of them are still able to be bred. I have not been breeding during the stay, just to, do the best that I can.
So there could be more of them.
There could be more servals, yes, but the servals were also approved with the with the first conditional use permit. It was just a limit of only 4 of the older ones, so that was where we were asking for finding of fact what made them dangerous compared to the other ones of them.
Yeah, and Commissioner, on that point, there was a condition that if an animal was under 6 months of age, basically a baby, it would not count. So if there was one of these kittens that was out there, she would have 6 months to find it somewhere else to go. And so if we put a hard cap of, say, no more than 13, 12, 14, whatever that is, with that 6 months deal, if there is a kitten, Jen can find, a place for that kitten to go. But it is the ones that are currently there, we want to be completely transparent with that portion of it, that they do breed, but they are a situation where they're not staying on premise. Within 6 months, they go off. And we have not increased at all during the pendency any of these cats.
That's what I wanted to know. Okay.
There's
all
also
right.
a condition, I'm not.
So
familiar, it says
as
once.
the little ones come and they can be weaned, then they're given away. I mean,
Right, I work with other zoos.
somebody
and
wants
USDA
those,
licensed things.
just the old cats that nobody wants to take.
One of the
Okay.
conditions was also that only a female is only allowed to have babies once a year, which goes along with the LDC code for domestic animals, and that was a condition they had put on in the past, and I agree to that.
Well, why don't you neuter them?
Because for conservation, preservation of the species, if there's something that goes on and there aren't any more of them, I mean, I have some bloodlines that are there to help with research and to keep these animals in the world we share with them.
There are no more of these are an extinct animal?
No, but to make them not be extinct is why I'm not going to neuter, and a surgery that's not necessary puts them in danger of their health. I don't keep all of them together. Like, there's not males and females with each other at all times, so that's how I keep them from breeding.
I see what you're saying, and believe me, I'm an outdoors person, and I'm all for conservation, and I'm all for protecting species forever. But all I'm saying is, here they're giving you grief over having them. You're continuing to allow them to breed, so there's more. You're giving them out to people, so now these people have them, they can breed them if that's what they want to do. To save yourself any kind of grief in the future, I'm saying neuter them, then you don't have that problem. As they age and they pass away, then your problem is alleviated completely and you're never going to have to worry about it again. It's the only thing, I just want to help you. I don't want to see you not have what you want to have. I'm just saying there's got to be a better way than, a constant battle to try to get this done. I feel like, and please don't take this the wrong way, but I feel like, the planning and zoning, we put these people on the board and we put our faith into them. And they're people that have a background in planning and zoning. They're all sharp individuals. So if we put them in that position, we should be trusting their judgment. Now, having said that, I want to help you as much as I possibly can. I have animals. They mean everything in the world to me. So I appreciate what you're doing, and I appreciate the way that you go out there and share them with children. Some of these kids have never seen an animal other than a dog or a cat. So I think that's very commendable on your part. But what I'm saying is, if planning and zoning is saying, this isn't what we want you to do, we have voted against it, then I'd like to see you try to do everything you can to make us happy, make them happy, and you be able to keep your animals. So that's all I'm saying.
Commissioner, one comment I would make, and this may alleviate some of your concerns, with the serval cats, she can't just give those to any member of the public. They have to go to research institutions, they have to go to another USDA license holder. So this is not a situation where, these are being dropped out in a countryside or anything like that, which I understand completely. But that's part of the reason why they would have to be euthanized, is there's only so many homes from them. And also, if you want to put that condition, as Jen said, that one female cat at a time can be pregnant, she'll accept it, and she will abide by it.
Well, something that does upset me a little bit is giving them to a research institute. I mean,
Not pharmaceutical. Jen only gives these, the National Institutes of Health. It's a genetic research. Why don't you tell about the research?
Yes, so it's like, it's not, it's definitely not passing off. We're not like having
okay.
tests and anything like that. So most of the research that mine are involved in is, I gather the research now, my vet does blood work of different ones and stuff that go to Brian Davis at the National Institute of Health and a couple different studies and research things over the years for that. Other ones, if they're going to go to other facilities, other educators like myself, somebody that has to be legal licensed to have them, like he was saying. But
Okay.
yeah, it's not, no, I'm definitely not against that. One of the species that I have that's very dear to my heart are chinchillas. None of those guys are going to be coats. I guarantee you that.
okay, all right.
There are no further questions. Would the applicant like to say anything independent of what has already been stated?
She's here to address, maybe after we have comments, Mr. Presiding Commissioner, she would be open for another round of questions under oath to make sure all concerns are addressed.
Okay. Mr. Counselor, I'm trying to make sure that I'm following procedure as scrupulously as possible. My thought is to go to Mr. Decker next, have him be sworn in and create his testimony, and then hear from the public. Is that the better way to go, or would you prefer to have those in favor testify and then opposition?
All in favor at once, and all in opposition, we go back and forth. One for, one against. Usually, I think it's, anyone speaking in favor goes first, and then
Right.
everyone speaking against would go last.
Yeah, well, I'm assuming given the vote, I don't want to make unwarranted assumptions, but as Mr. Decker is a member of the Planning and Zoning Board, I wanted to make sure that I was doing this in the proper order. So if that's your recommendation, then we will begin by hearing those who are in favor. After we've heard those persons who would like to speak in favor of the applicant's application, then we will hear those who are opposed, and we're just going to take it from there. As you come up, because we are taking this testimony under oath, as any person who wishes to speak comes up, if you would stop at the clerk and she will administer the oath, and then we will go from there. So, yes, sir.
I was just going to say, I thank the commission for its time and consideration.
So, if anyone would be wanting right now to speak in favor, please come forward. As this person is coming forward, just a reminder, make sure the green light is on, state your name, and then please speak clearly into the microphone so that we can hear your testimony.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Okay, the green light's on. Can you hear me okay through my mask?
Can all the other commissioners hear
Okay.
clearly now? Yeah, please
My
proceed.
name's Andy List, and I'm the one with the horses. And for the most part, they don't smell, but the poop does. Jen has been my neighbor since she moved in there. We were one of the first houses at the end of the cul-de-sac to build. And though I'm not happy to say it, my horses have gotten out during the time that she's lived there, and she has helped me catch them. They got out, the last time they got out was the night of July 4th. Fortunately, they, because I do interact with them and play with them a lot, they didn't go anywhere, because some of them have shoes on with boron to prevent them from slipping on the asphalt. There's no marks on the asphalt, so they never left my yard other than to go up into my neighbor's tip of his driveway, and you could see some hoof prints up there, but then they went back in and they didn't go anywhere. But they do get out. I have a draft horse, and he is pretty obnoxious about standing on the gates, and he literally just breaks them. And short of putting hot wire across it, that's the only solution I've come up with. And then if the hot wire, grass grows up in it and it quits working, he knows before I do. So Jen works on her programs. I've helped her with her programs. They're wonderful to watch those kids when they're interacting with the animals. I've also done therapeutic riding programs. I think that there's not enough of that in this world nowadays. So, and I know that my property value has not decreased. We also, my late husband and I, bought a house over on Windsor, and in order to try and have someone close to help us as we got older, he was disabled. Then he's died and we sold it, but I never even had to put it on the market. It was a private sale. I still have equity in the house because I'm the bank for the people that own it, but that property value went up considerably even in the few years that we owned it, and I know my property value has gone up. So anyway, I would just ask you to consider the good that she's doing and the fact that none of her animals are dangerous. They're not wild, they're not big. My horses are more dangerous than hers. If you ran up behind one of them, they'd kick you and put you in the hospital. I have no doubt. Thank you.
Are there any questions of the witness? Seeing none. Thank you very much. Is there anyone else wishing to speak in favor of the application?
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Hi, my name is Liz Bartels, and I used to be the inspector for Jennifer Kasserman from the USDA. I'm no longer with the USDA, and I'm only speaking of my personal opinion, not that of the USDA. But I have seen her place in comparable places. And she is very comparable to most facilities in at least the Midwest that I inspected. She never had problems. She was compliant when I was her inspector. And it can tell you a lot, in my opinion. I grew up in this area. I had been living in Iowa. I moved home, and I reached out because she's a good person. She's a good animal caretaker. And if she didn't do it right, I wouldn't have any contact with her. I wouldn't support it. I'm here mostly to answer your questions in reference to if you have any questions with the USDA stuff, because I am familiar with it. The last time I was at her place was the beginning of the school year in 2020.
Are there any questions or comments? Commissioner Wagner?
Thank you. Thanks for being here tonight, and I appreciate you pulling back the veil of the USDA secrets. My only question to you is the categories that are placed on the various animals, right? So you've got license, that you have to license, dangerous, and so on and so forth. So
Yes, sir.
just, I guess my question is if there is concern that some animals, one may consider dangerous, but they don't appear as dangerous on the list for USDA. Why is that, or maybe more broadly, how is that nomenclature determined, and what should we read into that nomenclature?
When I was an inspector, which is not current, so it may have changed since because there's always internal politics with the federal government. But the inspection guide was the same as when I inspected. And what it comes down to is everybody knows that lions, tigers, bears, wolves are dangerous animals. The history of them in public settings, there's plenty of history of injuries to staff and or the public. When it comes into the smaller felids, there really isn't the same situation. Any animal with teeth can bite, and with them being wild or exotic, they consider them have a higher potential of biting, but it doesn't mean they're gonna do it.
Gotcha.
It's just what standards are put on the animals' facilities. So like the 8-foot fence is required for the felids, even the servals. But it's not required for the porcupine, but she still puts a 6-foot fence around there because that's what's required. And when they were talking about the different levels and when you walk in and what's where, there's different requirements for different areas. And she exceeds what is required by the USDA. And it's everyone's own determination of what the standards of the USDA are, if they're minimum, compliant, but she exceeded those standards.
And last question, the reason why those animals that may not be termed non-dangerous need to be licensed anyway is because they are not...
They're exotic.
They're not found naturally here.
Correct.
Therefore, they have to be...
So the government wants to keep track of where they're
And
at.
know where they're at. Okay, very well. Thank you very much.
You're
Appreciate
welcome.
Any further questions of this witness? Seeing none, thank you very much.
Thank you.
Is there anyone else who would like to testify in favor of the application?
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
My name is Rachel Love. I am a teacher in the North Kansas City School District. I also work with Jen throughout the summer, traveling with her with these animals. Even some of the animals that are in question, we take to the libraries, we take to the schools. They visit. We have precautions when we're traveling with them and when we're in the public, and we also take very pride in choosing what animals to bring. So when we go to choose what hedgehog, if that hedgehog does not want to come up and wake up and be active that day, that hedgehog does not come. So we are always very cautious. Who do we bring? If they are not in the mood, those animals do not go to any of the programs that we do or to any of the classrooms that we attend. Now, some of these, the animals that are retired, those do not leave the facility. But we have taken servals to the public, Connet Public Libraries, to the St. Joe Public Library. They've been in the public schools as well. So keep that in mind, that these animals do interact with people and kids, and we take pride in picking who and when they do go to leave the facility.
Are there any questions? Seeing none, thank you very much. Is there anyone else who would like to testify in favor?
Do you swear affirm to tell the truth, the whole truth, and nothing but the truth? Hi, my name is Kelly White. I've spoke at all of these, so you might be familiar with me. I volunteer 2 to 3 days at the facility, as it's not ever left unattended. There's always somebody there. You know, everything that Jen does is very important. I do understand the reservations of the neighbors and things, you know, but I feel like that we really have did the burden of proof with everything. And, you know I've been coming out there almost 10 years. I do help with some of the programs as well. There are so many layers of protection for my safety, for the public safety. You know, she is very calculated with everything she does is in the best interest of the animals and the people that they're going to come in contact with. You know, I don't know what I will do without the animals, as, you know, I suffer from depression. They are very good therapeutic. I enjoy going out there. It gives me a purpose. And I love to see them bring children joy. Jen works, you know, now this year with, you know, some special needs children. She took them. Those were some of the pictures you saw. I mean, you don't even understand what, you know, just interaction with things that they don't get, like she said, dogs, cats, whatever. It really brings people a lot of joy. And I just hope that everybody really looks at all the facts and everything that's been presented as a whole, and understand that I feel like we do deserve to, you know, continue this. And, you know, I know that there might be some conditions, but I will be there every step of the way, you know, doing everything that Jen asks, everything that the county asks. You know, every day that I'm there, I make sure, you know, I do everything to the fullest of my ability to make sure that there is never a problem. So, you know, I just want to ensure everybody that, you know, this facility is not a danger to anybody. And if anybody has any questions for my daily routines or anything that I do, feel free to ask.
Are there any questions? Seeing none, thank you.
Thank you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Good evening. My name's Della Grantham. I've been with Jennifer for probably 15 years. I'm 75 years old. I know you've heard this before, but some of them haven't. I go in with every one of these animals. I clean them, I feed them, I play with them. I've never had a problem with any of these animals. We go to school programs, we go to elderly homes, we go to the Mid-Continent Public Libraries. We've had many people tell us it's the only time their children are up out of their beds, got their lunches ready, and they want to go to this program. Whether they've seen them before or not, they want to go to the library and see these animals. We've been asked back to all the Mid-Continent Public Libraries year after year after year. This is something that we enjoy doing. And like Rachel said, if the animal doesn't want to do it, they don't go. We don't force them to do anything. If they get to the school and they don't want to come out of their kennel, fine, they stay in it. We don't drag them out by the hair of their head. So I want you to know these animals are well taken care of, and my official job is I'm the official pooper scooper. And so I wanted you to know that they are taken care of and we do love them.
Were there any questions? No, that's okay. I see none, so thank you. Is there anyone else wishing to speak in favor of the application? Seeing none, are there any persons present who would like to speak in opposition to the application?
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Greg Ayers. I live at 8006 Windsor Drive, which is a property to the south of Miss Castleman. Mine borders at least 70% of her back line. I want to remind the council that this is a residential neighborhood. It's zoned R1, and there's no place for wild exotic animals. These may not be dangerous, but they're classified that. There's a concern for families and little kids running around too. So her signs that are on the property on two sides I know of for sure. The little green sign is about like that and about that tall. It says exotic, wild, dangerous facility. So it's hard to tell unless you're right up there next to it. When this first come about in 2015, we had a lot of people that were against it were here, but yet it was so deemed to give her the permit. Sort of, people were discouraged by that happening. And as Mr. Carpenter said 2 years ago when they voted 1-2 to deny it, that it should have never been in place to start with. But yet he went ahead and voted for it. Mr. Nolde voted the other two, and so it was denied. When the permit was granted back in 2015, Ms. Castleman failed to keep the number of animals that she was allotted at that level. She increased it and went over it. She also failed to establish a vegetation boundary inside her property so that people would not be able to see or the lights affect other neighbors. As far as the fence, her boundary fence, that was put up 35 years ago to prevent a dog from coming across my property who bit my son at that time. So it was hastily put up. So it really wasn't supported to keep animals, wild animals. It was supported to keep a dog in. They have since put up to make it 8 foot, but they didn't add any supports to the fence. So it could be easily knocked down by an animal coming from the outside, which there's a lot of deer running around out there that would want to jump or something like that. So it could be very easily knocked down. These may be soft and cuddly animals, but they still classified as wild, dangerous, and exotic. So they're not your normal house pets. And a lot of them are not native to the United States. They come from South America and other countries. So as to the property value, I have a great question on how accurate Zillow is as far as doing property. In fact, mine, when I looked it up, stated that I had so many rooms in it, it was very inaccurate. So there's an accuracy with Zillow as far as property values and things like that. As far as the neighbor selling his house next door, I spoke with him directly before it went on the market because I was interested in buying it. And I asked him up front if he disclosed that this wild and exotic facility was behind there. He did not. There's a question on the disclosure statement that should have been disclosed at so that it was public. He could set himself up for illegal if the people decide to back out and stuff like that. You know, you guys are responsible for keeping the citizens of this county safe, and that's why this should be denied. If the commission so desires to give her a permit, there's a big question in my mind as to you can get the permit the first time, do everything wrong, and you still continue to do that because she has showed a failure to follow the 15 items that she was supposed to do in that permit the first time. So, thank you.
I believe there's at least one inquiry, so if you could hang in there for a moment. Commissioner Johnson, I believe you wanted to be recognized.
Yes, thank you. Thank you for being here. I appreciate your comments. I do have some questions. I just want to clarify some things. So your biggest concern is safety. You're
Yes.
afraid of those animals getting out.
And it's a residential area. It's not designed for wild exotic animals. I believe the house that sold for $400,000, those exotic animal signs were put up after he purchased it and had moved in.
Okay, I want to talk about the safety aspect first. Which particular animals are you worried about for your safety?
Well, there were lynx and leopards there before, and the servants.
I don't think there's leopards. They look like leopards.
Well, they were big cats, because I could hear them growl from my deck at night.
So so right now of the cats that she has, you're worried about the servals?
Yes.
Anything else?
Not particularly. The porcupine, I mean, if those wild animals get out, they're gonna, cause damage to property.
Now, would you be concerned if she had a pit bull?
I'd be concerned if she had a pit bull.
How about if she had a German Shepherd?
No.
So there's certain dogs that you don't want her to have that you'd be concerned about?
The dogs are fine. The goats are fine. But there's also a number, according to the Clay County zoning, that you're allowed one animal unit per 3 acres. And she has far exceeded that.
Yeah, I get that. I get all the zoning stuff. I'm just trying to get down. I'm trying to think, okay, if I was her neighbor, why would I be concerned? What would scare me? What would I be afraid of getting out and give me, particularly in a rural neighborhood where those animals will probably be more in danger than anything else if they were to get out?
If I have my grandchild playing in my backyard and they get out, I'd be very concerned about it. And,
Okay.
Because they could hurt a young child. So I have safety issues. And the fence that could fall over at any time, because it is 35 years old or more.
Okay. Thank you.
Commissioner Withington, you wish to be recognized?
Thank you for coming and speaking tonight. Has any part of her fence fallen down?
No.
No.
But a strong wind, and we've had a lot of wind out there. Trees have been, branches knocked off and stuff like that. And any time that could happen to her fence.
Okay. And have any of her animals gotten out that you know of?
Not that I know of.
Okay. That's all I needed to know. Thank you.
Commissioner Lawson.
Quick question on the fence, because that is of a concern. So you're saying that she's got the fence, it's a properly tall fence.
It's roughly 8 feet high, yes.
But it's not supported?
It was originally put up as a 4-foot fence, and the gentleman put it up, the previous owner or 2 owners, put it up just to keep his dogs from coming across my property and biting my child. They had, since the last time, they went up and put another 4 foot on top of it, but they really didn't put posts to support that. It could fall down very easily. There's no support to that fence.
Okay, that makes sense. Okay, thank you, sir.
Further questions? Seeing none, thank you very
Thank
much.
you.
Is there anyone else wishing to speak in opposition to the application? Yes, Mr. Decker.
Yes. Good evening. My name's Tom Decker. I reside at 19810 Watkins Road, Lawson, Missouri. I joined the Clay County Planning and Zoning Commission with my first meeting on January 9th of 2014. January 8th, 2019, I was appointed chairman and remain the chairman today. I'm not here tonight to support or oppose the case being heard. I'm here tonight to present the facts, and I might parallel some of what Kip has already touched on, but there is a pattern here, and I'd like to present the facts to the commissioners. We did first hear this case on August 4th of 2015, and the vote then from the P&Z commissioners was 3-2, 3 in favor, and I was one of the commissioners that voted in favor. I very much respect the applicant's motivation, her program, helping the children, and I respect it 100%. Then the case was approved by the county commission September 21st, 2015. And this was a conditional use permit that was issued for a 5-year period. And it had approximately 15 conditions. In October of 2015, the applicant, well, I should back up. At the August P&Z meeting, the applicant was 100% good to go with the conditions set out in Attachment A, the 15 conditions. Everything was discussed. She's in agreement. Life is good. And I think the commission heard the case September 21st, approved it based on the conditions, and everyone's in agreement. In October of 2015, the applicant, for whatever reason, unbeknownst to me, filed claim against the Clay County Circuit Court. If she was unhappy with some of the conditions or the requirements, I don't know. Mr. Bear, the applicant's legal, he is correct that the applicant has not received any violations or code violations from P&Z, because when the applicant filed suit against the county in October, planning and zoning were instructed to stand down. So I feel bad for the staff. The staff's responsibility. They're responsible to hold up the LDC. We've got some issues, but they're being told to stand down. So Mr. Bear's correct. We can fast forward to April 2021. Anyway, here's the original resolution from 2015 with the 15 attachments. The April 21, one of the conditions was that the natural foliage or trees would be planted around the perimeter, and Ms. Kasserman implied that she had planted the trees, but they had died. So, fine. It was in May of 2021 that the applicant's attorney at the time, Mr. Ford, he proudly announced to the P&Z staff and board that the signs had been erected, the signs that were requested 5.5 years prior. In May of 2021, the applicant made an application to renew her conditional use permit, and it was denied unanimously by the Planning and Zoning Commissioners 5-0. We can fast forward again to July 11th of 2023. Again, the applicant applied to renew her CUP, and again, it was denied unanimously. Fast forward to September 5th, 2023, today, it's still business as usual. We're 3 years past the expiration date of the original CUP. The P&Z staff cannot inspect the property because the applicant has a case pending in the Clay County courts, and the applicant has pretty much had carte blanche for the last 8 years to do whatever she would like to do because P&Z cannot inspect the property. What I've witnessed through the minutes of the meetings, the hearings that we've heard with the applicant, she has established a precedent of noncompliance and disrespect to P&Z, disrespect to the Clay County Commission, disrespect to the Planning and Zoning Commissioners, and there's a pattern that what we say and what we do is two different things. And I feel the P&Z staff, they're responsible to hold up the land development code and parallel the comprehensive plan. They've issued a conditional use permit that's had quite a bit of opposition in the past, has been unanimously denied twice in the past, but the operation still exists. And that's all I have. So,
Commissioner Lawson, I believe you wish to be recognized?
Yeah, I do. Mr. Decker, thank you so much for serving on the board as long as you have, and I appreciate you coming this evening. Of all of the requirements that we have put forth, that you have put forth, other than the signs, have all of those been met?
no,
Do you know? And we don't know because we can't inspect, right?
correct. You could
Okay.
do a drive-by, but
I'm sorry?
you could do a drive-by, but
I
that's not,
guess.
you know.
Okay, and
Well, excuse me, you need to be recognized before you speak, Commissioner. And Commissioner Lawson has the floor. If she wishes to yield, I don't mind, but we do need to respect who has the floor.
I just had a couple more questions, and then, okay, so we don't know if all of the requirements have been met, and you have denied it, the Planning and Zoning Board, twice?
Unanimously, yes,
Twice,
ma'am.
okay, all right.
5-0 unanimous in April 21, 8-0 unanimous July of 23.
Okay, all right, all right. All right, that's all I have. I just wanted to make sure that we don't know at this point if all of the requests, other than we're sure there's some fencing up, we're sure that there are signs being put up, but that's all we really know for
Well,
100%.
The natural vegetation as of April 6, 21 was not in place. The original CUP, item number 12, quote, total maximum number of adult, exotic, dangerous wild animals at any one time is limited to 30. In part of our hearing on April 6th of 2021, one of the Planning and Zoning Commissioners asked Ms. Kasserman how many animals did she have on site of that day, April 6, 21. Quote, Ms. Kasserman said 65. She had 65 animals on her operation, April 6th of 2021, and the original CUP was written for 30.
30.
And there's just been a pattern. Some of these are petty issues that I could be here quite a while, but there's a pattern of, she set a precedence to not comply and disrespect P&Z and the commission.
Okay, that's all I have.
Commissioner Wagner was already in the queue, and then I'll go to Commissioner Johnson. So Commissioner Wagner.
Thank you.
I'm sorry, let me do that again.
There we
There
go.
you are.
Let me first, Tom, echo my colleagues' thanks for your service to this county.
Yes, sir.
It's often thankless, and you don't get paid enough. In fact, you don't get paid anything. And I'd offer you to double your salary if it would mean anything. But at any rate,
Yes,
thank
sir.
you. I kind of want to just kind of distill this down to the basic issue. And what I'm hearing is that what appears to me is the issue that has prompted the unanimous recommendation of declining the CUP, both times it's come before you, or the last two times it's come before you, is that the original requests and requirements that preceded it were really never done. Is that, or is there new things that caused the other two votes?
No, what you said is correct. Although, as Mr. Bear said, she's never received any code violations, but P&Z was instructed to stand down because it was in court. But, and what I'm quoting tonight, here's the minutes of our meeting from April 6, 2021, where Ms. Kasserman states she has 65 animals. But we can't go in and count them because
you can't go on property.
We can't go on property.
Yeah, yeah.
And then I know that Mr. Ford, Ms. Kasserman's previous lawyer or attorney, was pretty excited to announce at the May 4th, 2021 meeting that the signs had been put up. But it was 5.5 years after the initial CUP. And that's, I'm trying to stay to the facts, and this is the truth, I don't care. I respect what Jennifer's doing, and I think it's a wonderful program, but the 15 items that we had on the conditional use permit were not multi-million-dollar issues. They weren't climbing mountains. They weren't incomprehensible. They were ignored.
Gotcha. Thank you
Yes,
very
sir.
much. I appreciate it.
Commissioner Johnson.
Thank you. I apologize for interrupting, Commissioner Lawson. Can you list for me all of the requirements that she has not yet met?
Well, no, because we can't access the property.
So you don't know if they're met?
All I know is what I collect from the minutes of our meetings.
So we have 65 animals. I heard that quote. So
That was in April of '21.
So
I
over-
have no idea how many's there today. There
Okay,
might be
so-
15 there today, I don't know.
So we have April 21, at least at that time, she was over the limit, you think, of how many animals per her?
The original CUP was written
30.
for 30 animals.
Yeah, just 60, okay.
On
What are the
April 6,
requirements?
2021, she has 65
What other
animals.
requirements do we know she has not met?
I was questioning the emergency operation plan. I was told on July 11th, there was not an emergency operation plan on file, but I cannot document that.
So we don't know.
We don't know.
Is there anything that we know that she's not currently in, that she's out of requirements, that she has not met?
I think the natural vegetation, that was item 7 under the initial CUP, the natural vegetation, that's very questionable.
Natural vegetation, that's what you're saying?
Trees, yeah.
Trees.
Trees around the perimeter that were planted but died.
And what's the purpose of the trees? It's just a
Screening.
A layman for screening.
Yeah. That was condition number 7 under Exhibit A, August 2015.
Is there anything else that we know that she has not? I get there's some that you don't know either way because you can't confirm. But is there anything that you know for sure she did not meet? Any requirements that we've imposed on her?
Presently,
Right.
no,
Yes.
I don't know.
Okay.
And neither does P&Z because we can't
Right.
access
Yeah, I
the
got
facility.
So I'm just, because you had said earlier that she hasn't met, you know, a number of requirements, but we don't know that for sure, and that's what I'm trying to get at. By the way, I want to start this off by saying thank you as well for the work that you do. Commissioner Wagner talked about doubling your salary. I was going to triple it myself. So,
the only facts I can present is what I can gather from the minutes.
Right.
And the comments from Ms. Kesselman or her legal representative.
But the reason why I wanted to get some facts out here because I want to give them a chance to respond to those if they haven't had requirements. If there's any requirements that they have not met, I want them to be able to respond to that.
Here's the minutes right here. You know.
Okay, so right now, what I see is that she mentioned she has 65 animals when she's supposed to have 30. An EOP plan you're not sure of, and natural vegetation. Apparently the trees died.
Correct. Point is, you know, right after the approval of the CUP, we go to court and then we have like carte blanche to do whatever we want to do because P&Z is not allowed on the premises.
Right.
And Mr. Bear is right. There's no code violations, but hence we can't access the premises.
And we'd want to access the premise to see what? The number of animals?
To see if signage has been put up, number of animals.
Well, the signage you should be able to see without accessing the residents, right?
Pardon me?
The signage you should see from not accessing the residents.
Correct. You have to walk the perimeter.
Right, you can do that.
Yep.
What else do we need to see? What else do we need to go inside to see, besides the number of animals?
Could you repeat the question, please?
So you're saying we can't get inside her house. We don't have access to go inside to confirm that she's in compliance.
Correct.
What would we check on if she said, hey, come into my house today, you can check on, what would we check to see if she's in compliance in,
I
besides
guess
the number of animals?
we'd go back to the original CUP and address the 15 items.
That you'd find inside the house?
Well, some of these items would be indoors only, yes, sir.
Like what? And I know I sound like I'm grilling you. That's my 30 years in law
Number of
enforcement. I
animals.
apologize for that.
Primarily the number of animals.
What's that?
Primarily the number of animals.
Number of animals. Okay, got that one. Is there anything else we want to see in there?
Well.
Okay. Okay, so I'd
have to go through the
Yeah.
15
I'm putting you on the
items.
spot. I apologize. I don't mean to, I just thought maybe you knew off the top of your head there's something, that we really want to see in there that we're worried about or.
I'm just saying, it took 5.5 years to get signs put up.
Yeah.
You know, she agreed to 30 animals, and 5.5 years later, she's claiming she has 65.
Yeah. What do the signs say?
I drove by, I don't recall right off. They're not very big. It says the neighbor behind or to the south of her property.
There's a requirement that some verbiage that has to
No,
be
and
on there?
that's, you know, Mr. Bear had a good point there that if P&Z, if they have a specific size and specific font, whatever, that they would be glad to comply. The signs are pretty small, but there was no real
Is it
specification.
the sign itself is like danger, exotic animals here?
It just
or
says
what's
it's a EWD facility or, it's been several months since I drove by.
Okay. Okay, that's all. Thank you. Again, I appreciate the work you guys do. Thank you very much.
Yep.
And Commissioner Nolte, when it becomes appropriate, I probably need to interject a few things.
I'm sorry, say that one more time.
Whenever it becomes appropriate, I'd like to interject just a couple things.
Well, why don't you go ahead? I'm trying to get Commissioner Withington on, and the button's not responding, so I'm going to struggle with that for a moment. It's still in the wrong column, so I'm glad it's on. So is it relevant at this point, or can you hold it?
I can do either. It is relevant, but I certainly can defer.
I would prefer to defer to commissioners for their questions. So please, Commissioner Withington, proceed.
Okay, thank you. I'm not going to bore you with the thank you like all them and make a joke about your pay, but so your biggest concern has to do with the emergency plan, is that correct?
No,
I thought that's what you said.
My biggest concern is the lack of compliance with the conditional use permit.
Oh, I thought you recently just said that your biggest concern was, sorry about that. So I know you did mention that you hadn't seen it. Kip, you mentioned that you had seen it and you also saw the insurance, correct?
Yes, so the emergency plan, the applicant has asked that's a plan she does not want to get out because she doesn't want people to know the layout of the facility. So we did not provide that to any board members, but I've seen that, approved that, seen the insurance, and please keep in mind, there's several conditional use permits that had different conditions on them. So the 2015 conditions, we never enforced those. So, and I don't think it's that we don't have access to the property. I think Ms. Grasserman may give me access, but it's just that I can't enforce those conditions, and Kevin can correct me if I'm wrong, but I can't enforce those because we don't have an existing conditional use permit.
So, Mr. Decker, does that help ease your concern that staff has seen the plan?
Sure.
Okay.
And I respect if it's, should not be disclosed, but it does exist, then so be it.
Okay, so I'm glad we've cleared that up and addressed that.
That's just
concern.
one of the little items, and that's fine. But it's just, it took 5.5 years to get signs. We agreed to 30 animals. 5.5 years later, we got 65.
Yeah, I understand that. Can I ask Jennifer a question too?
I think right now, because inquiring of staff, I think is okay. I'm going to look for counselor, but I think right now we are in the portion where we are getting information from those, where we have passed the part where it is the in favor of, so I think we need to stay with even though Mr. Decker has indicated that he is not necessarily testifying in opposition, but for informational purposes only. I think we can certainly bring her up afterwards and then redirect, but I think to keep things in kind of their lane. Does that sound right, Mr. Counselor?
I certainly have no problem with bringing her up again at the end to have some follow-up questions, because that may certainly be appropriate. But I think it would probably be good to finish each witness and probably.
Okay.
And I would certainly want to see the applicant have the opportunity to do a final appeal, a final statement that she could make. But I think if we can make that inquiry at that time, we'll do that then.
Okay. So, Mr. Decker, when was it that P&Z quit inspecting the property?
Yeah, I can't speak for KIP. I think, I'd say in October 2015, when it went to court, P&Z was instructed to stand down.
Okay, so you guys haven't been on the property since 2015?
I can't speak for KIP, but I don't believe we have.
Kip Jones, Planning Director. So as part of the original Planning and Zoning Commission meeting in 2015, the Planning and Zoning Commission actually visited the site. So everybody visited the site then. And Jennifer can tell me if I'm wrong, but my recollection is we talked about the vegetative buffer as part of the 21 CUP. So I think I visited the site then, but it wasn't in a capacity to enforce those conditions. It was just, hey, come out and look at the property, tell me where I need to plant trees. We discussed it, and that was the extent of that meeting. Code violations, if I recall correctly, in 2015, we asked Jennifer to straighten up some debris around the property.
So it's just debris, nothing major?
No, we have not had code violations other than that. And we didn't even start a case on that.
Okay, so I can see the trees. I was going to ask Jennifer if she would come up, and she's already sworn in. She would say that she did plant the trees to ease one of your concerns. I'll ask that later. But I could see the trees dying. My neighbor planted 20 bushes around his property to give him privacy. The soil is bad. Half of his big old evergreen bushes or whatever died. So I could, if she testifies that she did plant them and they died, I can completely understand that, because I watched my neighbor plant a bunch of them this spring, and half of them are already dead. So I'm glad that we were able to have Kip ease your concern, though, about the emergency plan. So I'll wait to ask my questions of Jennifer next.
And I want to set the record straight. We do pay the Planning and Zoning Commission members. They get $10 a meeting. So.
I know she didn't
And I
offer to
spent
double his pay.
$16 in fuel to and fro.
We'll go to Commissioner Lawson, and then Counselor, if you could go ahead and give us the information that you would like for us to hear. Commissioner, oops,
It's blinking at me.
I know.
Let me see. Oh, there it goes.
There it is.
Thank you.
Sometimes you have to do it
Okay,
twice.
So let me ask you this, Mr. Decker. If we could get permission to go out there, and I'd say this to the whole commission, if we could get permission to go out there and look at it and have the list of the original request, count the animals, do everything, for me, if there were things that needed to be done, then I'd be willing to say, you've got blah amount of time. If in that time it's not done, it's over. But if everything were brought up to snuff, I don't blame this gentleman back here for saying that fence isn't secure. Because I know we had one of the grandkids over, and the guy next door's dog came over, and I had to practically step in between, or that dog would have bit her. So I appreciate fencing. That's got to be done. I think that's so important. We won't let people have a swimming pool in this county without a good fence around it to keep the kids out, so somebody doesn't drown. So I think that a completely secure fence is great. Number of animals should be done. If trees were planted, we can see that they died. Maybe you need to plant new ones. But all of the conditions should by now, since 2015, by now they sure in the heck should be met. So that would be my only concern, is if they gave her the necessary things to do, then that's the way it should be, because we hold everybody else's feet to the fire. That's for darn sure. A friend of mine tried to buy a house out in the county, and there was a barn that was less than 50 feet from the neighbor's fence. She was going to use that barn for animals. The county came out, checked it out, and told her, oh yeah, you can buy this property, you can have horses, but they can't go in that barn because it's too close to the neighbor. So the whole deal fell apart, So if we're going to have rules, let's enforce the damn rules or don't have them. It's that
I'm just
simple.
saying, you could go out today and make agreements and nobody knows. All I can do is that I can document that the applicant has set a precedent of non-compliance over a several-year period, over several issues, minor issues, signage, screening, These are the basics of, this is business 101. This is not rocket science. It's not zillions of dollars. And there's just been a precedent set of non-compliance. So what you agree to tonight and what you have next year, it's a crapshoot from my experiences in 8 years.
Okay.
Well, thank you very much.
Yep.
Appreciate it.
Yep.
Mr. Counselor, before we address the issue, one thing I want to address that Commissioner Lawson had raised, and that was the idea of commissioners going out there and looking at the property. Given the type, if we were talking about a regular action for this commission or regular issue, I don't know that that would be a problem, but since we are planning a zoning issue, and we may not, if I understand correctly, we are not considering information that is not imparted to all commissioners. If all commissioners went out, that would then trigger a notice of meeting. I'm a little bit concerned about the mechanics of how that would work.
Well, and I'll tell you, I didn't necessarily hear that Commissioner Lawson was suggesting that the body go out before a decision made. I thought it was more along the lines of, if we approve this, we want to make sure this is followed. And of course, Mr. Jones and his office would be empowered to do that. Absolutely.
Well, that was something that I wanted to clarify because I wasn't sure, so I wanted to give at least a legal read on that. So could you go ahead and explain the point that you wanted to do?
Okay. Yeah, absolutely. So again, I apologize if this is, I'm not offering evidence. I feel like maybe there's a little bit of confusion And to be honest, it's understandable confusion. This is a confusing topic, and it's a technical topic. In 2015 and then in 2021, decisions were made that were appealed to the court both times. Absolutely the right of any applicant to appeal a decision to the court. At that time, and still at this time, the court entered a stay order that essentially kind of set up the parameters of conduct. The appeals were of the decisions of this body. So to be really clear, there is no violation of a term of this body or the Planning and Zoning Commission because those orders aren't fully in place because of the appeal. So I understand the concept of non-compliance is a deep concern, perhaps. It isn't really applicable here because there's a stay order in place. And I'll tell you that as the person involved in the case, I have no evidence of a violation of the stay order. And so I just want to make sure that that's clear. Again, I'm not trying to offer evidence on what you're ultimately supposed to be deciding, but I don't think you should be deciding whether compliance exists on conditions that were never implemented. And I'll also say additionally, I don't think there's no direction to not oversee Ms. Caskerman's property. Anytime there's a code violation, whether it's in 2016, 18, 20, or this morning, Planning and Zoning can go out there. And so there might be a little confusion on that as well, but I want to be real clear that I want to keep us focused on what I believe are the topics for consideration tonight. And I don't think it is whether there was compliance on a condition that was not implemented in the past. So that's all I'll say for now.
If I can just recap what I think you're saying, just so it's clear in my own mind, what you're saying is our focus is the issue before us, which is whether to approve or not approve, not necessarily whether there are determine that. Our job is to act on the issue before us. Is that accurate?
Yes, mostly. I mean, so if a fully implemented CUP existed, and it had, let's say a 5-year CUP existed, no appeal, no court, nothing, just a 5-year CUP happened, and that person is here before you tonight to ask for a renewal of that CUP for an additional 5 years. And my belief is that if that person violated the conditions of the CUP in that first 5 years, I think that's relevant. What I'm suggesting is I don't think it's relevant for you to consider conditions that were never implemented.
Okay, thank you. Is that?
Okay.
My screen went blank,
know,
but
it's
Commissioner
okay.
Withington, I think is the next in the queue, so if you'd like to proceed.
So I certainly want to give anybody a chance to speak that wants to speak, but after hearing everything, I'm fully prepared to make a motion that we approve 2023-322 conditional use permit. I think the applicant has met the burden of proof to show that her property is safe, the animals are safe, they don't provide any danger to the surrounding people. She's also proved, her and her attorney proven that.
Commissioner, before you, it sounds like you're in the
Jerry,
point.
just let me finish.
This is the point of order.
Let me finish.
This is the point of order, if you please. I think while you can certainly make that motion, I think when you make that motion that we are still receiving testimony. There may be others who want to speak. So I think we should be hearing the testimony of others, including having the applicant come forward and talk about the points that you want. If you want to continue to make that motion, you're certainly welcome to, but I just want to caution you.
I want to make a motion that we approve 2023-322 conditional use permit.
Very well. Motion has been made for the approval of 2023-322. We can still hear testimony, Mr. Counselor?
If there's more testimony to be taken, sure.
Okay. Mr. Decker, had you completed your testimony, sir? And did anyone have any further questions of him before he's been interrupted?
Before who was interrupted?
Mr. Casserman, Mr. Decker.
He wasn't interrupted, you called on me.
I recognized you for an inquiry. I didn't realize, there's no way of me knowing you were going to make a motion. So with that, are there any other questions of Mr. Decker? Seeing none.
I've said my piece. I thank you for your time and thank you.
Thank you. Are there any other persons present who would like to speak in opposition? Seeing none, would the applicant like to make any closing comments?
Mr. Presiding, honorable person, presiding. Sorry.
Now, don't give me a swelled head here.
I will maintain your honor on that. Sorry, it's a force of habit. Jen, come on up. Do you mind if I just ask Jen some questions to kind of move it along and have her testify in response to my questions?
Mr. Counselor, is that procedurally okay to have one witness inquire of another one as we go forward?
I wouldn't consider him a witness. I mean, he's not sworn, so yeah, I think it's appropriate in this way.
Okay.
And I
Trying to
think
make
it'll
sure
help- I think it'll help expedite things as well.
Yeah.
Very good. Yes, please go ahead.
Ms. Casterman, you heard a testimony regarding a fence, and I believe it was characterized by a gentleman that it was falling down. For that fence, is that the only fence that you have on your property?
It is not.
Could you, I'm
It is
sorry.
not.
Thank you. That's what I was
Sorry.
going to ask you to do.
We'll do this thing here. Ms. Casterman, about the 8-foot in question, the 8-foot fence, in fact, was that in place when Mr. Jones was on the property and P&Z inspected it in 2015 or 2016?
The fence around the outside of the property is actually a 6-foot fence that the neighbor was referring to. It doesn't have, it's not an 8. The inside fence of 8 was there, except for on the gates, they were a 6-foot fence, and planning and zoning asked those to be raised to 8, and they were.
Okay. So planning and zoning did see the fences, and there is more than one fence that you have around the perimeter, correct?
Correct. Correct.
The other question beyond that, and this also doesn't include the fact that the animals themselves are in enclosures, that you spent over $100,000 to keep them secure?
Correct.
Okay. Ms. Casserman, you heard testimony regarding what was characterized as a lack of inspection by P&Z. Has P&Z ever requested to go do an inspection during the pendency of these?
They've not requested to do an inspection.
I can represent as well that I haven't received one as an attorney where they've asked to go on the property, and maybe that was a miscommunication on that part. But was the USDA inspecting your property during that entire period of time?
They have. I've had multiple inspections throughout the years, not just one.
And were they inspecting for instance, that your fences were secured?
Yes, they inspect everything.
Okay. And at the time of, Mr. Scarrett was talking about the number of animals. Just to clarify, the 30 animals were what they were willing to permit, not the number of animals that were actually on the premises at that time, correct?
There's 30 animals outside was the original thing that were, yes.
Okay. And so the 65 included animals that were inside?
Animals inside and domestic and companion pets.
Wait, so that 65 number included animals that are not even subject to the EDW regulations?
Correct.
Okay. So, and while this was appealed, there was a stay order in place that I believe council was referring to. That wasn't something that had 0 conditions on it. There were conditions attached to that stay, correct?
Yes.
And one of those conditions were no animal escapes, no increase in the amount of animals, no animals injuring people, is that correct?
Correct.
And did any of those incidents happen during the stay order?
No.
I think that's all the questions I have. If the commission has further questions for Ms. Casserman, she's more than happy to answer them.
Thank you. Commissioners, my screen here is blank, so I will ask you to get my attention and I will call on you manually. So Commissioner Lawson, I believe you sought recognition.
Can you please tell me how many animals you have on that property today?
Today, as of right now, 54.
I'm sorry, honey, I couldn't hear you.
54.
54?
54.
Okay. And and I don't care whether they're inside or outside, I'm saying you got 54 animals there, right?
Correct.
Okay. And then the back fence that the gentleman talked about, that, you added on to so that you met the requirements. Is that fence got supports that go all the way up to the top of that fence?
It has supports every 6 foot in ground. It's planning and zoning's inspected it, USDA's inspected it. It's a sturdy, solid fence. All I did to it was made it stronger since I've been there.
So the post every 6 feet, from the ground all the way to the top of the fence?
So the posts do not go all the way to the top of the fence. The fence is left, since it has a perimeter, to have a flap to it. Again, because it's to keep predators and people out of it. So it's supposed to have that give, so if they go to get it, they don't have a solid thing to grab on like a ladder to go over the fence.
But that isn't what I asked you.
Yeah.
The posts go from the floor to ground halfway up the fence, right? The top portion does not have a support every 6 feet.
The top 2 feet does not have a support every 6 feet,
Okay,
yes. I'm
that's what I
sorry.
wanted to know. Have all the requirements that originally were requested, have those requirements all been met now?
Commissioner, when you're referring to requirements, are you including the number of animals? Because we have had that as an issue. Or are you referring to the requirements that were appealed as well as the ones that went to circuit court?
Forget the circuit court. I'm saying what the planning and zoning originally had requested, the different, all of them.
I would advise my client, just to be clear, because she is under oath, and I want to protect her as an attorney, the requirements, if we have a list of those, we could put it in front of her. But there's been multiple applications that have gone through, and I don't want her to, I want her to be as accurate as possible. So
in other words, they haven't all been met.
Well, ma'am, the requirement that you're saying, if it is about the stuff that we appealed to circuit court, they wanted only 30 animals and 4 servals. We appealed that and that was stayed. And so, yes, she does not comply with that because we took issue with it and went to court, which is our right.
That just blows my mind. Okay, that's fine. That's all I have.
Commissioner Johnson, I believe you wanted to have a moment to be recognized.
Yeah, thank you. I don't want to offend anybody here, but I really personally think this whole process, this whole thing is really silly. I think this is government overreach at its best. And government does this kind of thing a lot. Certainly we don't want everybody to have these exotic animals all over the place, but there needs to be some responsibility, and I think that's checked out. And she has a track record of being responsible for these things. It's a great program that she has. If you haven't sseen it, you don't know anything about it, I'd encourage you to take a look at it. Actually, I got some texts tonight by some people that want to see it, now that they're hearing us talking about it. But, these animals that are supposed to be so dangerous or scary or we're worried about getting out, here's what they face if they get out. If they get out, those animals will face wild coyotes in that neighborhood, bobcats, rattlesnakes, skunks, possums, snapping turtles, and even beavers. One took out a tree at my house in a single day. I'm worried more about those things than about a turtle or a serval or any of these other things getting out, which aren't predatory. They're not going to come after humans. They're going to run away, if anything. So I just think it's crazy. These restrictions that we're putting on her and this program, and to have these animals, she's responsible. I can't believe we're in the weeds as much as we're on this thing. And by the way, I don't mean to offend the Planning Commission who looked at this. And they're looking at the letter of the law, but sometimes we get wrapped up in process over mission. We get wrapped up on what does it say? What does she have to do instead of, what's the whole purpose here? The whole purpose is, do we have someone who's being responsible with these exotic animals? Yes, she is. Not one has gotten out. She's got them in cages. She's got a fence up. She's got her signage up. Why are we battling this? This is crazy to me. So I'm going to support Commissioner Withington's motion on this.
Commissioner Wagner.
Thank you. After this discussion, I'm afraid to go to Commissioner Johnson's house for fear of all the animals that are there. I had to, I'm sorry. All joking aside, though, I agree. I'm not concerned about the animals that you have. I am sufficiently convinced that that there is more of a danger outside the fence than there is inside the fence. I guess where I am concerned, though, has to do with what I perceive, and you'll forgive me if I say it this way, but we don't like the answer that has been given previously by the commission, so we come back when the commission has changed.
exactly.
That is of concern to me, as it may lead to others doing the same down the pike. But it seems to me that the real issue here, at least to me, is whether or not if we put conditions on the CUP that they will be followed. Although I understand the county councilor's position that you really don't have rules because of how it has gone to the court, it does at least seem to me that there's some recognition of what has been put there in the past based on the attempt to put trees up for screening, the attempt to put up signage and so on. There's at least some thinking that this is desirable and should be done. But nevertheless, just because the trees died, that doesn't get rid of the obligation. You still have to plant the trees because that is a kind of a condition and not. It's somewhat of a circular argument. So I guess my feeling is, and this is why I got up a few moments ago to talk to Kip, there's no reason that you have to have a 5-year cut. We can give one, but you don't have to have one. And I'm reminded, you should appreciate this, Commissioner, I remember Ronald Reagan,
God bless him.
who said, "Trust but verify." And I would just just make the observation that, and I guess this is where I finally get to a question for you, is one could give something less than 5 years to see if the conditions that are here, as listed in Exhibit A, are actually performed. I note that there is a performance placed in here of 6 months to put in the proper screening, if I can find that. In Exhibit A number 4, although I don't know how that is then followed through on whether or not that is actually done. But I guess, 2 questions then, with all that in mind. 1, must it be a CUP of 5 years? And number 2, do you currently comply with what is listed here in Exhibit A?
So for the first question of the minimum amount of time, I'd have to look at the land code again, but I think there is a solution, because I believe there is a minimum, or at least a practice of doing 5 years, is that you can put as a condition by 8 months you do this, by 10 months you do that, and if at any time there's a violation, it goes away. So the length of time that you have there, you can put conditions where if they aren't complied with, that the permit goes away.
Mm-hmm.
And the one thing I would say as well is that, our ability to appeal anything to the circuit court about the decision, a permit, is 30 days.
Mm-hmm.
So if it's something where it's 6 months, 10 months after, that cabins us in of our ability to take issue, if that's the concern that the commissioners have, that we've gone to circuit court. So there's a way to structure it that gives you what you want. I would defer to the county councilor if there's a minimum. I wasn't prepared for that question, but I want to check on that.
No, I understand that. Because what strikes me is that part of the reason why this is a somewhat circular discussion is that because of the existence of the appeals, there is at least some feeling that I'm gathering from both Mr. Decker and from staff that we cannot verify because we are somehow precluded from doing so due to the fact that it has gone that route. So my interest is trying to figure out how to alleviate that so we can verify that whatever conditions are put on actually can be verified, and therefore we know whether or not what has been agreed to has been adhered to. So I'll just leave it at that. I'll just throw those out. I don't know if the county councilor has a position on any of those things I've brought up. Thank you.
Please go ahead.
Just quickly, so on the current iteration of this is for 5 years. That's under proposed condition 2. Proposed condition 4 would require compliance on the vegetative screening within 6 months, all other conditions within 3 months, and then proposed condition number 3 specifically states that the CUP can be revoked at any time if there's a violation of the code or of the conditions. Now that's how the proposed conditions currently read.
Are you finished? Yes. Excuse me, Commissioner Carpenter, I believe you want to be recognized?
I do. Honestly, though, only once we've wrapped up questions for Ms. Casserman.
I don't know if anyone else, because my screen won't tell me, but I plan to just ask one question, but if you'd like to go ahead and... Okay. I've not been on the P&Z board very long, but something I noticed was that the chairman, at the conclusion of each hearing, as we are preparing for a vote, asks this question, and that is, do you understand the requirements under the CUP? Do you understand what those requirements are, and do you agree to them? Has that been the experience of yourself?
For the original CUP that was granted with what the staff report that I'd been given that day, yes, the staff report that came out that was signed and published was not the same. The resolution was not the same as the draft that I had been given. That was where the appeal came in. The list of the animals, none of them were listed on our original thing at that meeting with the commissioners.
Are you talking about the original one back in 2015?
Yes.
What about the subsequent ones?
About the what? I'm sorry.
What about any subsequent actions beyond that?
I don't.
Mr. Presiding Commissioner, that was the only one that was approved, so they
Okay.
were all denials
All right.
beyond that.
Thank you. Commissioner Carpenter.
Thank you. I just want to make sure everybody's wrapped up asking questions, because I don't want to interrupt that portion. So if you all want to, I think we're done asking questions, right? Is that fair to say?
After you speak, I intend to recognize Commissioner Withington to close.
Yeah. Okay. Well, I just wanted, if you all wanted to sit down, I think that would be fine.
I thank the commission for its time.
If you agree. Okay. All right. So here's my view on this thing. Director Jones gave us the timeline earlier as to how this has all played out over the years. Back in 2015, a conditional use permit was sought by the applicant, Ms. Casserman, and the county commission, as the elected government of Clay County, granted that conditional use permit. They said yes. Now, I think in terms of the role of government, we absolutely have a role to have reasonable rules and regulations around exotic animals, the way that those might impact the neighbors, public safety, and I think that's a perfectly reasonable thing to have. And I think in 2015, as that was being assessed, I certainly hope that the elected commissioners at that time did their due diligence before making the decision to grant the conditional use permit. But once they did that, they said to a business operation, yes, you may perform your business operation here in Clay County. She has subsequently done so. According to her sworn testimony today, has spent hundreds of thousands of dollars as part of that business operation. We've received reports that there haven't been any issues with regard to animals getting out, people getting injured, anything along those lines during the course of those years. And to county council's point, a stay was put by the circuit court as an appeal was being made by Ms. Casserman, which was a perfectly legal and thing to do, and she had every right to do it. And so violations purportedly of the original CUP, I think taking those into account here this evening, as county council has suggested, would be the incorrect choice. The court intervened and put a stay on the original CUP. So I'll say what I said a couple years ago when we had this before us, which is that I don't know if I was on the commission back in 2015, if I would have voted yes to grant the conditional use permit. I think there are plenty of reasons to be concerned about having, you know, an exotic animal operation in a relatively residential area. And I think that would be perfectly valid reason to have denied it at that time, but that isn't what happened. What happened is the government said yes. Hundreds of thousands of dollars have been invested. The business has been going. They've been doing all their wonderful things with the kids and all the other things they do. And I think for the government now to come in all these years later and pull the rug out from underneath an existing business operation would be government overreach. I think it would be wrong. You know, I regret, you know, in terms of what happened a couple of years ago, obviously we had a split vote on that. And, you know, that's kept this thing in court. And here we are again. And in terms of bringing it before a new commission, once again, I think they have every right to do that. So I'm not sure why that should count against them either. You know, they are an existing Clay County business operation, and they're operating under the rules allowed by our various county ordinances and by, you know, the courts of the land. So, you know, in my view, this is a pretty straightforward yes to approve. I will be supporting the motion to approve. I certainly hope that with regard to the conditions that are put in place going forward, that, you know, that it's a smoother path forward in terms of those being abided by. I feel like we've received testimony today about all of the different conditions that they're perfectly happy to agree to. And it's my hope that that is how this plays out going forward and this issue gets put to rest. But I really, you know, I'll just stress the point again, which is, yes, government regulations are necessary. I'm pro good regulations. But once you greenlight a company and tell them yes, you are permitted to operate your business in this manner on this location, and they proceed to do so without incident and invest hundreds of thousands of dollars, I think it would be the wrong choice for us to now come back and take that away from them. I also found council's responses to the various criteria with regard to impacting land values, with regard to safety, et cetera. I found those to be compelling arguments, and I do feel that they've met those standards. For all those reasons, I'll be voting yes, and thank you for your time.
Commissioner Withington, you're recognized to close, unless there, were there any other comments? Oh, I'm sorry, I'll come right to you, but.
I'm sorry.
Commissioner Wagner.
I apologize. This is probably either for the county councilor or for Kip. In Exhibit A number 4, where it provides for 6 months to comply with vegetative screening and 3 months to comply with all other conditions, and failure to do so will result in revocation of the conditional use permit. What is the process by which, and how long is that process by which that communication is done if they are found to have not complied with that, and the revocation is then given?
Kip Jones, Planning Director. So we would obviously start working with the applicant as soon as this is approved to look at the conditions. If those conditions aren't met in that time frame in there, then we would basically send a case to County Commission at the next available meeting to consider that revocation of that CUP. That's not something staff would do. It would come back before this board.
Very well. Thank you very much.
If there are no other comments, then I will recognize Commissioner Withington for his closing remarks, then go to a vote.
Yeah, I close.
Very well. With that.
I do have kind of a comment about process a little bit here.
Please, go ahead.
Much more complicated than usual because we're talking about the animals. And I will suggest, I will suggest that the conditions need to be worked on more depending on your vote. And I don't think it's possible to have the conditions fully set out in a document for you tonight. My suggestion would be, to be honest, my suggestion would be that we take a 5-minute recess to see if we've got a parameter on conditions potentially. Then you could vote, and depending on how the vote turns out, If it's in the affirmative, you could vote tonight, but then approve the conditions next week or whenever Kip feels comfortable getting the conditions approved. Because we do have conditions, and I don't want to be rash with the conditions that need to be approved because they are very specific, in my opinion, they would be very specific to animals based on the testimony. And I think that really has to be worked out in a way that can be addressed with you tonight, but then we would have some direction on those conditions. So
I think that, because you're right, this is unusual as far as the issues we usually deal with, as far as resolutions and ordinances, but it is even unusual for planning and zoning, which takes more of a character of a judicial procedure than it does a legislative procedure. I think, I think a 5-minute break just to kind of do that, then we will come back and take up the motion that is on the floor. So, and not to mention the fact we've been going for some time. So I think some of us might like a little bit of a break. So it is roughly, what, about 13 before the hour. Let's try to reconvene no later than 5 minutes before the hour. That gives about 7 or 8 minutes. Would that be, do you think, sufficient to try to get it done? Very well. For that, we will stand down until that time, 5 minutes before the hour. Thank you.
light goes on.
We are back from us standing down, standing at ease. I believe some discussion was had before we go forward. Commissioner Withington, with your permission, I would like to have the counselor give us some additional information, and then if there are no questions of the counselor, then go forward with your motion. So, Mr. Counselor, if you'd like to give us what you have.
Okay, so here's my suggestion is that you take your vote tonight, either up or down. If it is up, if you approve it by majority, we need to address conditions. I don't necessarily want to dive into those right now, but maybe take your vote, and then if it's up, then maybe we could go through an outline of conditions. You could give us direction on those conditions, and then we'll have a document with those conditions ready for you next week.
And is this something?
And you would approve only the conditions next week, because you would have approved the resolution tonight.
Now, is that something that you feel you have consensus on from the applicant?
I believe within a certain parameter that the applicant would agree to the conditions that I will suggest.
Would it be appropriate for me to ask applicant and/or their counsel, or are we kind of beyond that? I'm trying to be as scrupulous as possible with procedure, so that's why I'm asking.
No, I mean, I think if you want to ask if they're generally speaking on board with this concept, I think that'd be appropriate. Because understand, there's going to be some technical sides of this. I don't know how you're going to, what direction you're going to give us.
One moment. Commissioner Wagner, did you have something you wanted to say?
Yeah, question for the county councilor. If I take your suggestion, does that mean that next week Exhibit A on this resolution changes, or is next week something in addition to Exhibit A comes before us?
It will Exhibit A will change. It will almost all be additional language or changed language to help understand what the parameters are going to be. So Exhibit A will change.
So now I'm getting into the procedure. So does that mean we will next week we would simply look back at this resolution and make changes, or is it a brand new resolution that comes forward with that?
What I anticipate is, depending on the direction we get tonight, that Kip and I would work out the conditions, and then they would be put onto a new document and a new Exhibit A for you to see. But the only things that would be on there would be things that you would have hopefully given some direction on tonight.
I see. Thank you. Thank you.
So procedurally, we would vote this evening on 2023-322. Assume for a moment that it was passed.
Yes.
It passed. Next week, or assuming next week, will we be taking it up as a
Approving the
revisit,
conditions.
or will it be a new new resolution?
It'll be approving the conditions, and I'll work through kind of the process. I'm not quite sure if it will just kind of revote or just on the conditions. I'm going to think through that a little bit.
And should we decide to go down that road, how does that affect the motion on the table? Is the motion on the table, would that allow us to go forward with that route?
The current motion is to approve, so yes.
So you don't need any adjustment onto the the motion to
That's
be able to go
correct.
down this road? Okay, I'm
That's
trying to make
correct.
sure that we don't box ourselves in inadvertently. Mr. Counselor, and I'm not looking to get any necessarily, specific commitments at this moment, but as far as the process goes outlined by County Counselor, are you and your client in agreement with that process?
Yes, Mr. Presiding Commissioner.
Oh, go ahead and turn on your mic there. There you go.
Yes, Mr. Presiding Commissioner. I've spoken with Mr. Graham. I think we have the contours of it, and generally what he has just laid out, I think would work. We would have no objection to that procedure. And that way, I do think one thing would potentially be agreed to findings of fact and conclusions of law, because that's one thing that we could do, but we could work that out. And I would stipulate to work with Mr. Graham to make sure the procedure is all buttoned up. So I have no objection to what he just stated as the procedure for that vote.
And while next week would be preferable, obviously, if there's need for more time, we would like to be informed as a commission, certainly, but but we can use that as a target, but still coming out with a good agreement is the primary mission. Are there any commissioners that have questions about this particular process? Commissioner Wagner?
Thank you. Sorry, in the weeds. It would seem to me that an amendment would be a good idea to suggest that there is going to be changes coming within an Exhibit A or empowering that to occur. Otherwise, I guess my question would be, if you went forward with an Exhibit A discussion and whenever you came back there was no agreement to it, then you would still have this as the voted on cup. So I guess I just wonder, does there not need to be some link to the further action that you've suggested, however that may be done?
I understand the concern, because that's the issue I'm trying to figure out, is the cleanest way to do this in two parts. Because what I don't want to do, for sure, is have the discussion and vote again next week on the underlying CUP. And I certainly don't want to take evidence, because I think the record is closed, you've taken your evidence. Right. We don't want new evidence to occur. To be honest, and I don't want citizens to be contacting you over the week as well, because that would create its own problem. So I think voting on the CUP,
Well, is the language of whatever comes back next week to replace whatever may be voted on here today, is that part of the verbiage that will go into what comes to us next week?
My suggestion is that we vote to grant the CUP with the conditions to be voted on next week. Just like that. So the CUP would be granted. Because right now, because there are certain things in Exhibit A that are probably going to be taken out because they're going to become unnecessary based on what the new conditions are going to be.
Well, then can I maybe suggest to the commissioner that made the original to do that verbiage, to say with Exhibit A verbiage coming next week?
Okay.
I just like something in the record that says, here's the follow-up action.
Yep.
I think you're right. I think that would be a lot cleaner, because we need to say that, we pass it with the, I don't know, condition may be the wrong word, but with the proviso that we will be defining the particular items under, I guess Exhibit A is, I think, what you referred to it as. Does that make sense? Because that way we are stating within the motion that we intend to take that up and that we intend to revisit that subject. So, I mean, I do feel more comfortable, as Commissioner Wagner said, if we express that in our motion, and that makes the vote more clear, I think.
I'm fine with that.
So you guys are fine with that?
We are fine with that. A statement that is a motion to approve subject to a subsequent vote, approving the conditions by the full commission.
So then I'll make the motion that.
Are you, before you do that, you need to withdraw the motion on the floor.
Okay, so then I withdraw the motion to approve 2023-322 conditional use permit.
Now you can make your next motion.
So now I would like to make a motion that we approve 2023-322 conditional use permit with tonight, but then approve Exhibit A next week. Is that right?
Is that acceptable as parliamentarily?
Yeah, that works.
I'm tired, man.
It works.
Okay, motion is on the floor. Discussion? I see none. So with that, please, I'm sorry, you're recognized to close.
I close.
Please call the roll.
Commissioner Withington?
Yes.
Commissioner Johnson?
Yes.
Commissioner Lawson?
No.
Commissioner Wagner?
Aye.
Commissioner Carpenter?
Yes.
Motion passes 4-1.
So now I'd like to have just a quick discussion on conditions. So we get some direction on what to put in this. And I'll give you, and we've come out with some ideas that I think track with the conversation tonight.
By the way, something that I would also like you to address is what we need to do as commissioners in the interim between now and then, what we are allowed to hear, what we are allowed to discuss with the public, just to keep us in our lanes, so to speak.
I think the record's closed. And so I'm never going to tell you not to talk to a citizen. But the vote has been taken. The record is closed. And I would leave it at that. You can have whatever conversation you want with the citizen, of course.
Sure, okay. I just wanted to verify that because if we were to put it off, we're putting half of it off, basically. And I wanted to make sure that there was no doubt that we were acting in a way that would not cause legal complications down the road. Very good. Okay, yes, if you'd like to give us a little bit of a flavor of what seems to be happening with it, is everybody okay with that?
I'll walk through the potential conditions that I think I heard and/or have talked about with council. And, maybe for each one, kind of, if there's somebody that doesn't like it or doesn't agree to it, let me know, but I'll just kind of walk through them. So the first is specifically to the 3 cats. On the lynx, there are 3 current ones. I think the agreement was that there would be no new ones. They would be grandfathered in, they'd be allowed to live out the rest of their lives. And then once that happens, there would be no more lynx. Everybody good with that? Yeah. Okay. With the caracal, there's 1 current caracal. It is in a zoo. We think it's in Portland. The agreement is it will not come back. There will be no caracals. Good? With the servals, there are 12 currently. Made sense to put on a limit. And I'll tell you that Ms. Casserman and her council believe that limit should be 15. I think whatever, you tell me your ballpark you're comfortable with, and we'll see if they're agreeable, but the suggested limit was 15.
I like 15.
Everybody okay with that? Yeah. Okay. All right. What's that? 15. And then I like the language of 6 months and younger don't count towards that number, so that if there is a litter or pups, or whatever the right term is, they can be rehomed.
That does make sense because there can be unplanned additions, and it gives them time to act on that unexpected circumstance.
And then, does everybody have access to this document on your screen that has Exhibit A in it?
Yeah.
So I think that what I would like to do is avoid having us micromanage individual animals. Say, you get this many of this, this many of this, this many of this, and then Kip becomes the census taker whenever he's over there. On the second page, there is a chart, an AU chart, animal unit chart. So that's already in the document. My suggestion, and I think it's been agreed to, is that we just come up with a number of non-felids that we would all agree to. So that however many tortoises versus porcupines, whatever the number, if you've got 3 of one, 4 of one, now it's 5 of this one and 2 of this one, the overall number is what we care about, not micromanaging individual animals. So right now the number is 3.9 on this chart. My suggestion is we take away the cats, because we've already dealt with them separately, and we just say that the non-felids would be capped at an AU number. And I suggested 2.75, they suggested 3. I don't have heartache over either. If you take out the non-felids right now, that number is about 2.54, I think, is what they currently have. So there's a little buffer to go a little higher, but not a lot higher.
I'm good with 3.
3? Everybody good with 3?
Yeah, and by the way, go ahead.
Felines?
No. So the approach I'm suggesting is we've already set very specific limits on the felines.
Yeah.
Okay, so we're taking those out.
And keep them?
They keep them, yes. Other than those, the non-feline limits would be 3 animal units. Right now, she's about 2.5 and change. And this would cover everything else. And however she wants.
3 per type?
No, 3. So an animal unit is one animal unit, I believe, somebody tell me if I'm wrong, I think it's 1 cow per acre. It's considered 1 cow per acre. And so an animal unit is a way that those in the animal industry categorize.
I see what you're saying.
So for example,
yeah.
a ferret is 0.02 animal units. So that's how they do it. But it's a workable approach. So again, we're not micromanaging animals, but they understand the limit. They can't have 300 animals out there. So the idea was 3 animal units, which would give them what they have now, plus slightly more depending on the animal. And if they want a bunch of goats, they're gonna run it, because goats have a large number. So if they turn into a goat farm, they're not gonna have many animals, but that'll be up to them.
Has staff weighed in at all on what the numbers you're throwing out there?
Yes, so we talked about it, we all talked about it
Okay.
together. I think we're all reasonably comfortable with this.
What I
approach.
wanted to avoid was not including staff's opinion in these things, because we have them there for their expertise and for a reason. So I want to make sure that we weren't overriding a staff opinion unless we knew what we were doing.
So this is what Kip has agreed to?
That's a problem.
You're comfortable with this?
It's a problem.
Okay. Yeah.
Okay.
All right, I like 2.75 also.
Now you're back, now you're at
Wait,
270?
that's what staff says, I'll just say 275.
We would really appreciate 3.
You want to flip a coin?
So this is an example, so we need some consensus, and, this could be hammered out next week, I'd prefer not to. I'd prefer to give some direction so we have a clean document for you.
Jay's staring at me.
I mean, from my point of view, if you say 3 of whatever animal or 4, it's relatively meaningless, because this is not an area that I have a lot of expertise in.
The difference between one animal unit is a lot of animals, depending on
Yeah.
what we're talking about, a lot. So, unless it's a cow, or a pig, I think a pig is a big one too.
All right, let's just go with 3, it's a round number, whole number. Jay.
Okay.
Peer pressure, Jay.
All right, then, so that approach it seems workable, so we'll do that. I heard 3. Then the other individual conditions, I'm just gonna run through them and make sure, and if anybody doesn't like them, let me know. Condition, no new felid species, no introduction. So that 3 animal units cannot include a new felid of any type. No venomous animals. No animals on the USDA's dangerous or potentially dangerous list. And Ms. Cashman would agree to provide KIP with all USDA inspection reports. So the USDA will come out at least once a year, and whenever one of those reports comes out, it gets turned over to KIP. So, and they will do the monitoring of the animals as in addition to us.
And for those specific conditions, the venomous animals, the dangerous and potentially dangerous, those will get flagged by USDA if they're there. So that should give you some comfort that those conditions, there's going to be 2 sets of eyes checking it, both feds and the commission staff.
So
I do
Or I
like
should
the
say
idea of
P&Z.
being compliant with FDA and how they are rating them. That gives, because these are people who have researched this more, and it makes a consistency in what an individual can expect when they're trying to start a business. It's like, okay, I don't have to worry about the Fed saying one thing, the local saying another. All lines up, they can check the box and go on and do their business. I'm sorry, Commissioner Withington, go ahead.
So you guys had said that the USDA does surprise inspections. Have they already done one for 2022? Or not
This year?
This, I'm tired, sorry, 2023? Oh,
Yeah,
she's not?
I wouldn't
So-
say
so you'll
it's just-
provide- So you'll provide that for this year?
Yes, absolutely.
Okay.
Commissioner Wagner, I think you had something to say?
Yeah, well, first I want to make sure, was that kind of the conditions, was that the list of the
That's
conditions?
it.
Okay.
Plus what's already on the list.
Plus what's already on there, okay, and
Oh.
so that's good to know, because I was going back to the concern of screening signage, those sorts of things. I think the number 4 on the exhibit kind of speaks to that. I don't know if there was discussion related to additional signage or anything like that, or improved signage. I think I am most concerned about the physical nature of the property and how screening and warnings, if you'll accept that term, are done, because to me, those are the things that are fencing. So I won't offer anything specific, but just to say that it's those physical things that have to happen on the property that are the most easy to see, and most easy to see if there's an issue, whether or not there's been compliance. So however you wish to address them, fine with me, but I do just want to make sure that they are addressed when you come back.
Our expectation as the applicant is that Mr. Jones will come out, and where he tells us to plant a tree, we will plant a tree. And if there's an issue with the fence that he sees, we will fix the issue with the fence. And also, the fence being secured, that's going to be checked by USDA as well. So, our expectation is what P&Z staff says is for screening and signage, we will comply with.
And on the fencing piece, just so I have an understanding, I understand what you have interior to the property. In my mind, it's that as well as on the edge of the property. So again, I'm not going to tell you what it needs to be.
Sure.
But just to make sure that those are addressed in some fashion, because that seemed to be a potential issue. So however staff wishes to have that discussion with you is fine by me, so.
One of our things, and I want to assure the commission of this, is we want full clarity with staff of the expectations. We want to meet them. We want to show you guys that we're meeting them. So we're going to have that discussion with council and Mr. Jones, and we will work that out. That's one of the reasons why we're agreeing to bifurcate this, to make sure it's absolutely crystal clear for each and every one of you that we are fulfilling every condition.
There's something that, I'm sorry, something that struck me was the tree screens and that they died, so they were not replaced. That's not, I don't know if that's the case or not, but that would be something that I would have some concerns about. So I don't want to get into the issue itself,
Sure.
But should that be the case, that would be a concern. If it's not the case, then good. So I just wanted to point out that is something that I was trying to get some handle on.
A question for Commissioner Wagner. Are you suggesting that you want different language on screening, or are you just want Mr. Jones to hear you say it so that he is enforcing that in the future?
More the latter. I just
Okay.
want to make sure that, we speak to it a little bit here, but as fencing seemed to be an issue brought up earlier, again, I'm not going to swear to any expertise because those scary bobcats that my colleague talked about, they're going to jump them anyway. But all kidding aside, since that was brought up as an issue, realizing that there's kind of two layers of that fencing to the subject property, that whatever that makes the most sense to staff as to how that is to be dealt with. I'm not going to, I am no expert in this, but it seems that needs to be addressed. However, it seems to be most fitting.
Okay.
I have a question about that, Jerry.
Yes, please go ahead.
So this is going to be a very ignorant question, and maybe it was covered, I didn't hear it. But what is the purpose of the screen, the vegetative screening? What are we screening? Something in or out, or?
Well, so if you look at number 7,
right?
Screening must be in the form of natural vegetation that adequately shields the view from Hauser Street and adjacent properties. So I take it as a more visual.
So the neighbors can't see in.
That's how I read it.
It's like an eyesore kind of a deal.
Yeah, that's how I read it.
Really? I'd rather see exotic animals myself, but all right.
Okay, does that kind of give us what we?
And it gives me direction, I think.
And has anybody got any further questions? Because if I recall correctly, Commissioner Withington? Oh, nothing on the table, okay. So we have nothing else, that's what we did vote on. So we have nothing else that we need to vote on, we can conclude it after this?
Vote's been taken, direction's been given. We'll have
That's what we
conditions ready for you next week.
Okay, that sounds great. If, and unless anyone else has any comments, and please don't. Though we seem to have put our due diligence in on this. That ends our regular agenda. That brings us to discussion items. First item on for discussion, Senate Bill 190, Commissioner Lawson.
Okay. Due to the importance of this Senate Bill 190, and due to the fact that it's late and there's a lot to talk about with it, I talked with Jerry earlier, and we're going to go ahead and hold this discussion until next week. But I would say that on the agenda, under discussion items next week, or however we do this, I want to get this thing completed and, and get some consensus and get it where we can get this discussed early next week so we can put a close to this.
And before we leave that subject, I think that one of the things that Commissioner Lawson would like to see is maybe we go ahead and start, ask council to put together some kind of a resolution. I think you had some discussions with her, so something we might be able to review at some point. Does that make sense?
Yeah. From my perspective, I would like to have the discussion and get some consensus and some direction on what that looks like, because it will not be a simple document to put together, given the different versions and iterations that are out there in the state and the different readings that might exist from the statute. So my preference would be to have a discussion and get some direction before we start putting together ordinances.
Go ahead, please.
No, I disagree with that. I'm in a horrible mood tonight. Somebody give me a beer or something. I don't know. Anyway, here's the bottom line. There were 105 examples that we brought to you. Not really, 5. But one of them was from MAC, and it was a pretty darn good example. Why can't we work off of that? And it pretty well addresses exactly what the person has to meet to be able to do it. You know, all of the key points would be in that document. And we've been jacking with this thing since before the governor signed the bill. And now we've all come to a pretty good consensus on the team that let's go forward and let's get this thing written up and get it done. So my feeling is, depending on how the rest of the commission feels, I'd like to go ahead and utilize MAC as their guideline, as our document, and just proceed along that line, get that written. We can then come back together and look at that document, scrutinize it, and then decide if this is the way, what we want to do. And if it is, if not, we make our changes and then go forward and have it finalized. But it's a heck of a lot easier to have a completed document that everybody can scrutinize and make their changes versus just meeting together. Hell, we couldn't get together on this bill. I mean, on this one item tonight. So it would just be better if we had a guideline to be able to sit and talk and discuss it, is my feeling.
Well, that would be a super simple approach. I'm fine with that.
Okay.
My suggestion would be, let's just distribute the MAC version and let's talk about that. That'd be super simple. And
Okay.
then just give, that way you can have that by tomorrow morning and give everyone time to look at it and actually, start giving some feedback for.
We already have it.
Does everybody
Yeah,
have
but
it?
I thought you'd fill it in with all the pertinent information, so it looked like an actual document. That's all.
Yeah, Diana sent that out to everybody after I
Yeah,
forwarded
she
it to her.
did,
Yeah.
everybody.
Okay.
We
And
all looked
we
at it.
can turn this into something from us.
Yes,
I mean,
that's what I
but-
want.
Yeah.
But I
Exactly.
thought somebody wanted
I just
a
didn't
really
say it
deep
right.
dive into the document with a lot of changes.
Okay.
That's a different issue.
Okay.
Maybe just with the broad strokes. Have the other commissioners gotten the other versions, the ones from all the other counties?
I
Yeah,
sent some
Diana sent
to
Greene
everybody.
County, St. Charles County.
Okay, good. That's what I was
Yeah.
wondering, if you guys got all that information.
Did you
Well,
get
because
those?
that way you'll have that for the discussion.
Yeah.
I want to make sure that had been distributed.
Quick question.
Yes, sir.
I get that we want to not talk about this whole thing tonight, but there are people that sat here for 3.5 hours waiting to,
Yeah,
I think,
no
to talk
kidding.
about this. Did you already talk with them, or?
Well-
Would it be possible for them to speak tonight if they want to speak on it?
Absolutely, if they want to. They had told me to go ahead, I talked to them, and they
Okay.
said to go ahead and
Yeah.
hold it till next week so we could really look at it, and I was hoping by that time we had a document then that we could actually say, this is what we're gonna use.
Yeah, and I agree with that. I agree with Commissioner Lawson. If we can get a document together, it's too bad you weren't in some of those, that last meeting with us. You weren't in there, were you?
I didn't get an invitation to the last one for some reason. I didn't even know it was
I know
happening.
you probably made somebody mad the one before or something. But,
Lot of
yeah,
folks.
because that last one, we kind of summarized, I think, everything that we wanted to put together in a document. But yeah, I think if we had a draft basically to work with that we can all play with, and it'd move things along a lot quicker. I think it'll go pretty quick too, actually, if we get one that's.
Yeah, because I think that's what we agreed to, all of the committee, that we had, that let's proceed and let's get this thing done.
Yeah.
So,
Yes, Mr. Auditor, did you wish to, I mean, we seem to be having the discussion anyway, so
yeah.
just kind of fill us in a little on what you have in mind.
Yeah, Victor Hurlbert, Clay County Auditor. I do sit on that subcommittee that, the county's been meeting about Senate Bill 190, so I just offer my, thoughts on what that committee has discussed. I think I appreciate and frankly agree with Commissioner Lawson on having something to work with. I guess I would throw, I do have some reservations with the MAC, or the Missouri Association of Counties template. There are a number of pitfalls with it. They have a retroactive application for the credit as opposed to prospective going forward. They don't make any expansion of eligibility. There are some pitfalls in the law as far as who's eligible having to be on Social Security. We've seen examples of other counties where they're expanding that eligibility. They're taking that discretion to do so. Retired teachers, retired railroad workers, just using an age of 62 years old that the General Assembly could also amend in next year, perhaps. So I guess I would just caution as far as if there is a template to work from, you might look at something like, I really like the St. Charles County, in my opinion. They made a couple of other things they did good in there as far as no credit on general obligation debt. I had a conversation with, fire chief here about that concern. A lot of our municipalities, local governments have that concern, as well as the blind pension fund. I don't think the MAC legislation made that recommendation. State legislative research said, we shouldn't do that. And so, I mean, I appreciate where MAC's coming from. They went exactly from the law, and and that might be something that council recommends. But I guess I would just say, from discussions committee has had, wouldn't recommend the MAC template.
Can I say something?
Absolutely, go ahead.
And I know what you're saying, I agree. One of the things that we had talked about was the feasibility that we would get the document completed, proceed with it by what the bill was, the actual 190 bill. And then if they made changes in Jeff City, then we would make an amendment or addendum, whatever is the proper word. And we would do that to go ahead and then make the changes necessary to be more inclusive.
Well, that could be another approach too. But I guess I just mentioned those are some of the reservations we've discussed with MAC. So.
Commissioner Johnson.
Is there any chance that we could get our auditor to actually put the draft together, because he knows so much about this, and then forward it to the counselor to review and then distribute to us?
Yeah.
I mean, would you be willing to do something like that?
I'd be willing to, but Victor Hurlbert, County Auditor, I would most certainly defer to council on. I mean, I could get a very,
I bet he'd love to have you do it. No, I don't mean do it for. I mean, put together, because you have a lot of information. You've seen a lot of drafts already. You've seen probably most of the drafts that are out there. You know what we want. You've been sitting in those meetings. Find the best draft, or mesh together the best draft that you think we have that meets what we want. Forward to him. Let him put his finishing lawyer touches on it and distribute it to the rest of us.
Yeah.
I mean, I know I'm asking.
Well, I'll also say Assessor Tracy Baldwin has counsel of his own in the assessment department, and they wrote up a draft different than, a little bit different than MAC as far as some of the points I mentioned there. And so his counsel vetted that, so that could be, another, boilerplate. And Greene County, my understanding, really reflected a lot of that draft.
It'd be really good if you guys work together on it then, huh?
Yeah, so I think that could be a path, absolutely. So.
I like the idea you kind of doing the preliminary and because you have that kind of a mind.
You want to say something?
And then you can have council, whichever one, scrutinize it, and then we'll discuss it. Does that work?
I'd be happy to do that if that's.
Is that okay?
Think so.
Are you okay with that?
That's fine.
Commissioner Wagner, did you want to add something?
I was just going to say, maybe to the earlier point that our auditor has stated, it seems to me that some changes are going to come down the pike.
Yeah.
And so to the extent that we can, I don't know if anticipation may be too strong a word, or anticipates too strong a word, but it does seem to me, not having viewed all these different drafts, that some provide more exposure to us than others. And so I tend to, you'll love this, I tend to be a little conservative on how far we go. With that in mind, that was for you. And trying to, because of that, if there are changes that we don't have a lot of risk out there, that would be my only suggestion. And I have a feeling you'll probably think similarly, but I just want to put that idea
I
out there.
appreciate that. Yeah, I've seen similar language of, any judicial ruling, any, change in legislation would basically rule our ordinance null and void, until,
Thank you.
And the thing is, the only thing I've heard that I have some concern about is that it should be simple to put together. It's not. There are a lot of moving parts here. I mean, every time we've had discussions on it, there's been something, I didn't think about, as you say, the debt levies. That's another complication. So there are a lot of moving parts here, and I think I think having more discussions on it's a good idea, because we want to do it right as we can out of the gate. That doesn't mean we have to take forever and a day to do it, but that does mean there's a certain amount of detail that has to be paid attention to, I believe. Commissioner Withington, did you wish to be recognized?
Will you be able to have that for us next week?
if that's what.
Yeah, can you have that for us tomorrow? I need a review, but you think you'll be able to have it for us next week?
I'm sorry?
A rough draft?
Yeah, we could have a rough draft, I think, by next week. Yeah.
And I know the committee's meeting with the school districts on Monday.
Yes, we are.
Have we met with any of the other taxing jurisdictions? Like special road districts maybe, or fire protection districts?
We haven't yet, but we will.
So, if, I remember you had said you wanted to maybe get this done by November?
Yeah.
So are you gonna get those scheduled like in the next 2 weeks? Okay.
And I would think, just with the timeline for the agenda, I might say I need, next week to draft it to get on the following meeting, if that makes sense.
Okay.
So yeah, not next Thursday's meeting, because that gives me tomorrow, which it could be done, but yeah.
Yeah, no, I just want to get this done. We've been talking about it since
Hell
July,
yeah. No kidding.
and we really haven't had too many conversations about it. I mean, we've had meetings about the Royals, we've talked about them so many times, it's time to actually get something else done, so.
Well, no, and here's the thing, we've worked very hard. And I want to get into that next week when we really discuss this heavily, of all the things that have been happening with this.
Yeah, no,
I
I know you guys have, but I'm just saying, us as a whole body, we haven't had.
And that's what my plan was to do tonight.
Yeah,
was
well,
to-
and that's what I had asked for, yeah,
Yeah.
but I'm just saying, I wasn't taking a shot.
No,
at
I
it.
know
Yeah,
that.
yeah.
I know that.
No, I was just saying, as a whole body, we really
Yeah.
haven't discussed this,
Yeah.
so.
And we need to get it done, I agree.
Okay. Anybody else have anything to say on the subject? If we bring it up for discussion next time, it'd be my recommendation, if we could, because it may well generate citizens, that if it is on next week's agenda, if it is prepared and we are ready to discuss it, might not be the worst idea to move that particular discussion item up on the agenda so that we can make sure that citizens who make a point of being here have the opportunity to have their comments heard.
Well, and something that Scott mentioned is that where we have this, the discussion items, maybe we could do those before the consent agenda, and then, do it that way, flip-flop those.
We can do anything we want, as long as we have a majority vote. Yeah, we can move one discussion item up, keep the others where they are.
Okay.
It's the will of the commission, whatever the will of the commission, the majority wants to do,
Okay,
we
well,
can
let's
certainly
do
do. But yeah, I say that just because I wanted to make sure that it was out there, that as a courtesy to our citizens, we should move, as a general practice, we unfortunately didn't get that done today, but as a general practice, if we anticipate a number of citizens showing up for an issue, we should try to put it as early on the agenda as is practical. If there's nothing else, we will move on to purchasing update from the purchasing manager.
Yes, Commissioners, I know the hour's getting late, but the following agendas look like they're filling up. So if you could please bear with us, we're going to do 2 quick presentations. The first one coming from our purchasing manager, Leslie Burton, and we will try to be brief with our presentations.
If you could turn on your mic, there you go.
Awesome. Good evening, Commissioners. Thank you all for sticking around. I promise I'm going to make this as quick as possible. First of all, in addition to myself, which I guess I need to introduce myself, my name is Leslie Burton. I'm the purchasing agent for Clay County. In addition to myself, there are 3 other staff members down at the Quick building. So that's how quick I'm going to make this. We are responsible for administering a hybrid procurement system. We provide direction and oversight to protect the integrity of the procurement process using nationally recognized best practices, resulting in the highest value for our county government and our citizens. Our mission and vision statement posted up there. Our vision is to be an accredited and trusted partner delivering impeccable customer service while fostering a collaborative relationship and serving the best interests of the county and the community. Our mission is to support all county departments by ethically and cost-effectively procuring quality products and services while following the guidelines established by the state of Missouri and Clay County to protect the public funds entrusted to us by the citizens we serve. While our name designates purchasing, we truly are a procurement team. Purchasing is the physical act of buying, whereas procurement is more creation of value. Purchasing seeks lowest cost, whereas we are seeking the highest value. Purchasing is reactive, whereas our department is proactive. Purchasing resolves an immediate need, while procurement fosters long-term solutions. I'm a little hangry tonight, so I'm going to refer to this as a pie. So if you look at the bottom portion of this pie, this is especially the orange and the red section. That's the purchasing portion of the entire procurement life cycle. So that purchasing portion, that's going to be your creation of requisitions to your actual purchasing to receipt of goods. None of that stuff is actually done in the purchasing department. And then in that purple bottom portion of the pie, that's the accounts payable portion. Again, that isn't really done in our office, but we assist everybody who has questions about payment or where their PO is in the process. So this upper half of the pie, this is the bulk of the meat and potatoes of our department. So this is where we analyze expenditures with specific suppliers. We identify suppliers. We issue solicitations, evaluate contract performance, and manage those contracts along with those supplier relationships. I'm sure you're probably asking yourself, how do we do everything that it is that we do? And we have a whole lot of resources. The bulk of our department is, the foundation is all laid out for us. We follow statutes, and of those statutes that we follow, they define the purchasing office, procurement office. They define statutory spend limits, defines the process for sole source and emergency purchases. It defines our competitive bid requirements. In addition to the statutes, our Clay County Code of Ordinances, Chapter 37, specifically outlines purchasing, further defines purchasing guidelines, how to place orders, how to receive, how to write specifications, professional organizations that we're members of. If I could, just draw attention to NIGP, that is our National Institute of Government Procurement. We've adopted their code of ethics, along with, we're pursuing accreditation through NIGP along with our professional certifications. Briefly, if I could, just touch on artificial intelligence. It's becoming prevalent throughout our communities, and it's getting harder and harder to tell what has been photoshopped and what hasn't been. Just so you all are aware, I'm pretty good at identifying what has been photoshopped, and this looks pretty darn legit to me. So if William Shakespeare thinks it's an important question to ask, so do we. So to bid or not to bid, we ask that question all the time. We also answer that question by asking a ton more questions. Such as, what is your funding source? How quickly do you need it? Are you unsatisfied or satisfied with your current supplier? Did I already say funding source? I'm not sure if I did or not, but that's super duper important because it is. Is there an available cooperative contract? And what exactly are cooperative contracts? They're pretty prevalent throughout the county. They save time. They add value, and they kind of bridge the gap between those contracts that we don't currently have in place for a need that we do have. Various other solicitation types that we issue are RFIs. Those are requests for information. Those are going to be namely software. Those are the bulk of those. RFQs, requests for qualifications. Engineering, architects, those types of services. RFPs, requests for proposals, those are going to be for services needed throughout the county. Professional services, IFBs, that's your big one in the middle. Those are mostly for commodities, construction projects, bridges and whatnot, where cost is your prevalent awarding factor. And then sole source. Those are where there's one feasible source that exists, and majority of the time that's going to be your software maintenance, annual upgrades and such. So with that being said, I hope, sweet, that was like super quick, I hope. Yeah, so any questions, I welcome them.
By the way, thank you for the presentation. Also, you made what could be a dry subject very amusing, so thank you for making it as entertaining as you did. And thank you also for remaining so late to help go.
Thank you, appreciate it.
Thank you very much. And then the next, I'm sorry.
Yes, we have one more presentation, and we're going to hear from our Recorder of Deeds, Recorder Sandy Brock.
Hi, I'm Sandy Brock, and I appreciate you taking the time to listen to me. I know it's late. I'm really going to cut a lot of this out because I know we're ready to get home, but I would really love to encourage every one of you to stop by at my office and visit and kind of look through the records and how they've been done throughout the years. It's really kind of interesting if you like history. So this is our staff members. I am lucky enough to have awesome staff, and altogether we have 71 years and 6 months experience in our office. So in our office, we do all kinds of deeds. Some are just regular land transfers like warranty deeds, beneficiary deeds, quitclaim deeds, releases, subdivision plats, military discharges, and marriage licenses. They're all really important. They're all legal documents. This is kind of a chart on how our workflow goes through the day. So you'll see the majority of the green up there is our e-records. The blue is, I'm sorry, I lost my place. The blue is recording that is either walk-in or mail. The yellow is marriage license, and the red is certified copies. That's kind of how our workflow goes during the day. So a lot of it is e-record or electronic filing. We cannot give legal advice. So If someone walks into the office and they're wanting us to help prepare a document, we cannot do that because we do not determine legality or validity of a document. If it comes in and it meets all state of Missouri formatting requirements, by law, we have to record it, even if we think it's suspicious. So a lot of our office is historical. Land records started with handwriting, which is really neat because you had to take handwriting classes at the very beginning to actually work in our office back in 1822, so when the county was established. And throughout history, of course, technology's changed, and now you could actually access records online. And so we do have an actual online access that you can actually sign up for. You can actually even have certain criteria that you will enter, like your name, and it will send you alerts if something's filed on your property. And I hope I cut that short enough. So do you have any questions for me?
As I'd said before, thank you for making the subject interesting and entertaining and for remaining here with us. Are there any questions or comments from commissioners?
No? Well, please stop by and see us when we get back in our office. Thank you.
Thank you very much. That brings us to county administrator comments.
No comments, just that the next meeting, which is going to come too fast if we don't get to go home at some point, gentlemen. Our next commission business session is next Thursday, October the 12th at 6 p.m. in this building.
Very good. Commissioner comments, Commissioner Johnson. Commissioner Carpenter.
No comments, thank you.
Commissioner Withington. Commissioner Lawson. Commissioner Wagner. Thank you to the staff for working so hard and so late tonight. And with that, we are adjourned. Thank you.